party leaders here in present and members of political parties here in present, members of the press, civil society, and of course our able aides who are here with us. Members of, did I recognize the press? Yes, as we're all here today before this joint committee to further consult on the elections bill which has been tabled before the National Assembly, the plenary, and referred to this joint committee. So on my own behalf and on behalf of members of this joint committee, I welcome you all to this session. Before we commence business proper, may we introduce ourselves so that we know each other before we actually go into consultation proper. So may I allow the committee members, honorable members, to introduce themselves first. Thank you. Honorable members, can we do the introduction? We start from you.
Good morning. My name is Honorable Martin. I'm a member of the Human Rights Committee, but I also stand here to represent as the interim committee.
Thank you. I'm not sure whether you can. I think this time around we were only one hat. Is it?
Good morning. My name is Yanshu Jete. I am the Vice Chair of the Local Government Lands IEC Committee and also a member of the Human Rights Committee. Thank you.
Any member here? Okay. Mr. Mende, take it. Mr. What's his name again, sir? Yes.
Good morning. My name is Honorable Alaji Exo, member of the local government.
Who is at the edge here?
Also representing the Jumala constituency.
Good morning. Bileji Tunkara, member of the regional government committee, representing Kanana constituency.
Morning. My name is Honorable Sari Jao, member of the member of the regional government committee.
Good morning. Alhaji Estabo, member of the Kaman North, Human Rights and Concern Matters member.
Morning, Honorable Madisisi.
Good morning, Honorable Swahili Ture, Vice Chair, Human Rights Committee.
Good morning, everyone. I'm Honorable Bakari Kamara, and I'm now Assembly Member of Kenya Central and member of the Human Rights and Constitutional Matters Committee.
Good morning. I'm Honorable Eva Jallo, member for Yara Central Constituency and a member of the Regional Governance Committee, IEC ombudsman.
Good morning. Mayor Sinseka, nominated member and member of Human Rights and Constitutional Matters.
Yes, I am Honorable Fodi Enembrame, member for Tumana constituency and a member of the Select Committee in the Regional Government Land Ombudsman.
Honorable members, Camera.
Good morning. I am Honorable Sunkari Baji, member for Regional Government Land, IEC and Ombudsman.
Good morning. I'm Honorable Momodu Kamara, member for Fonyi Bitankaranan and member of the Human Rights and Constitutional Matters Committee.
Good morning. I am Honorable Omar Siste, Nam Nyamena East, a member of the Human Rights and Constitutional Matters Committee.
Good morning, Honorable Sin Dora, now for the Wasani constituency, member of the local government.
Good morning. I'm Honorable Dami Jesane, National Assembly member for Burkina South, a member of Regional Governance Land, IEC and Ombudsman.
Musa Amunyasi, Chairperson of the Committee on Regional Government, Honorable Ombudsman and the IEC, and the co-chair of the Joint Committee.
Thank you very much. My name is Mariam Denton, Chairperson of the Constitutional Matters Committee, also co-chair of the Joint Committee. We have our staff with us, Mr. Gallo, led by Mr. Gallo. Then can we have the introduction of representatives of political parties for the witnesses who are here? Yes.
What about our technical?
Yes, I have. In fact, I did say Well, in the person of Mr. Sir, we have others. You may introduce yourselves then. Yes.
I am Modu Tafapal, subject matter specialist for Regional Government Select Committee, ombudsman and IEC.
They are the subject matter specialists.
Good morning, my name is Modu Sir, subject matter specialist for Regional Governance, ombudsman and IEC matters.
Thank you. We now have the introduction of the political parties.
My name is Amami Fandintal. I am the spokesperson for the United Democratic Party.
Ramadan Mubarak to all of you. My name is Siri Dabo, leader of the United Democratic Party, and the president in waiting.
Good morning, my name is Rahman James. I'm representing Gambia for all political party of IEC, and I'm the deputy political leader.
Good morning, everyone. I am Amadou Khan, the deputy party leader 2 of the Gambia Democratic Congress. Thank you all.
My name is Joseph Acosta. I'm from EPDP, Admin Secretary 2.
My name is Abdurrahman Jallo, and I am the Admin Secretary 1 of Gambia Party for Democracy and Progress.
My name is Sansa, Information Secretary, PDOIs.
Ramadan Mubarak to my dad. I'm Saban Musa Husseini Ali Bachili, the party leader of Gambia Action Party, the next government.
Good morning, my name is Lamin Bidima, Minister of Environment and Climate Change, party leader of the National Convention Party.
Good morning, I am Siri Jai, Deputy Spokesperson, National People's Party.
Good morning, my name is Mohammed Kando Riafa, Administrative Secretary, Gambia Action Party.
Members of the civil society,
Good morning, I will recognize my name, National Assembly member, and also represent my party, NRB.
Good morning, my name is Modi Jain, GDC Electoral Committee.
Good morning, my name is Mohamed Umbo, Admin Secretary, Gambia Democratic Congress.
Thank you. Thank
Madam Chair, is the meeting open for non-members?
non-members of the committee. No, they can observe. They can observe. No, they can observe. They can, because the session is open. The session is open. It's not a closed session, so they can observe. Please, can we have one meeting? Please, thank you. Thank you. Thank you very much. Thank you. Thank you. I'm being informed that there are 17 officially registered parties, but we have 10 here. I think the last one, 18. Yeah, as of last week, or as of today, 18. But we have representatives of only 10. So I don't know the reason why the other 8 are not here. I can understand the latest one, probably the committee wasn't aware and they couldn't have been sent invitation. But my learned...
The latest one, by the time they got registered, the letters are already dispatched.
Yes, I understand. By the time the letters were the letters had already been dispatched. Then the last one got registered. Thank you. Honorable Sabasandia, please, can you introduce yourself?
Yes, I'm Honorable Kumantule, member of Sabasandia and member of the Human Rights Commission.
Yes, thank you. I'll help you. Thank you very much. Once again, good morning, everybody, and we welcome. Yes. Well, you can perform a double role. Yes.
I was also going to say, because I'm representing my party, I also did not receive any.
You are representing your party.
What I'm saying is that I did not receive any, so I would like to know how and which part was involved.
Well, is the question directed to the chair or to the secretary? No, I think that is not correct. That is not right. You can raise your concerns and the chair can take it up with the secretariat. But I am sure you don't expect the chair to be following letters to parties. No, but you raise your concern very well and it will be taken up. Yeah, but definitely the chair cannot take responsibility. Thank you. No, it's okay. It's okay.
I vividly remember on Thursday, together with London, we were trying to confirm the number of parties that existed. We had 16. I even gave London the contact number of an individual at IEC who please would call to give him the 17th party. So if Honorable Kamara is saying that the APRC is not received their communication, that's surprising. But what we can do
is... Please, can we have one meeting, please, and let us have some decorum and order, please. Now, let me allow the co-chair. He has some explanation vis-a-vis the local government aspect of the bill.
Thank you very much. What I want to say here is, it was on Thursday while we were in the field, Wednesday rather, not even Thursday. While we were in the field, I was called by the director of committee, London Joe, and at the time, he had 16 parties on his list. As he went through the list, I was able to recollect the last party that he missed, and I gave him the name of that party. And as of that Wednesday, he gave me the assurance that all the letters were to be dispatched. So if there is a party claiming that they have not received their letter inviting them to this meeting, which is a party I belong to, that is strange. But all we can do is we will continue with the business. Notwithstanding, we'll find out from London as to who was responsible for the dispatch of the letters, and that individual can confirm that whether the said parties have actually received their letters or not. Well, this was last week Wednesday. That's all I want to share. And then again at the time, we had only 17 registered parties. That is why when the co-chair was making the announcement, she made mention that we have 10 parties out of 17, because the 18th party was not registered at the time, and they are not invited to this particular forum. So I want members to understand it that way.
In fact, let's not prolong this dialogue.
There's another hand from the same party who claimed not to have received. Let's hear what he has to say.
I want to make a general observation. Because we were informed that out of the 60 or 70, 10 parties were present. In the event the National Assembly faulted in the delivery of the letters, that would not be the fault of those parties absent. Would they be given an opportunity also to put that input?
Thank you. Yeah. Or we can even sort it out and compromise. We're continuing with the engagement. And the parties that have been omitted will be written to, and they will join either the Banjul or Serekunda, KMC or West Coast region meetings. And then their concerns will be heard as a political party. So I think we can move forward and continue. Thank you very much. Now we've done the introduction. Now I just want to give a summary of the mandate of this joint committee. And first of all, to say that the Elections Bill 2020 was referred to this joint committee by the plenary, where it was actually tabled during the last session, and that is the first ordinary session in the 2021 legislative year. Now, the mandate of the committee is to scrutinize, consider, and prepare a report on the bill for presentation to the plenary as required under our standing orders. I don't want to bore everybody with the detailed provisions of the standing orders, but we are all familiar with them. And in the venture that is in the process of the consultation, the Joint Committee is expected to make reference to the Parent Act, the 1997 Constitution, and also to invite relevant witnesses and stakeholders and subject matter specialists to guide us through the process. Now, highlighting on the role of political parties in relation to the bill, from inception, the activities of the committee has invited, actually the Ministry of Justice was the mover of the motion, that is the bill, Ministry of Local Government and Lands, Foreign Affairs, Finance. In addition, the committee has also received the IEC, that is the Independent Electoral Commission, to give an overview of the bill. And all of them will be serving as observers throughout the process. So please, Secretariat, let us ensure that the Ministry of Justice, it was clearly stated, and the IEC will accompany us throughout the sessions. So I don't know why they are not here, because I'm sure the political parties will have their views, and especially justice when it comes to amendments, will need to capture the views. I'm surprised that they are not here. Now, the committee, of course, knows very well, and we all know that political parties are a major stakeholder in relation to the election bill, which is very, very obvious. And the bill fundamentally regulates, or is supposed to regulate and administer the role, eligibility, and existence of political parties in the Gambia. And based on these reasons, your presence is highly appreciated. And we would welcome your views and expect your concerns to be raised and any proposals, so that we can look at it as a committee, as a joint committee, and take a decision before we finally prepare our report for it to be tabled before the plenary. And that is to say that your opinions, concerns, and contributions will significantly assist this joint committee to prepare a very comprehensive report for presentation to the plenary. Now, you are not only invited to react to the questions and concerns of honorable members which will be raised, but that everybody will be given the opportunity to address the committee on any area of concern. I just wish to add that your presence today here is not just centered on party politics, but on the interest of the country as a whole. And as I said earlier on behalf of the committee and the technical team of the National Assembly, we express our gratitude and appreciation for you coming to consult with us. And on that note, I will say thank you for that. And honorable members who were at a tour last week, divided into two groups. One is South Bank, and the other one went to the North Bank. And I think they went up to URR, and now they had priority questions for during the course of the outreach. They had developed a questionnaire for which they have agreed that they will be put across so that they will seek your advice and wisdom on the areas that were covered during the tour. And the questionnaires were put to members of the public during their meetings at North Bank, LRR, URR, and the CRR, both North and South. And as I said again, your advice will be greatly valued, recorded, and taken into consideration. Now the questionnaire was one of them. Well, the questionnaire was based on one, whether the IEC should be given the right at all to receive grants or donation, taking into consideration their mandate. I have to read it out because I cannot really detail it offhand. Then there was the issue of attestations. Should attestations be allowed as part of the following documents: birth certificate, national ID card, and passport for issuance of a voter's card? And if yes, who should be the issuing authority, the alcalo, sefolo, or 5 elderly in the community, or both? These were questions that were put across to the members of the community, and they had their reaction, but I think it is only reasonable also to share that with members of the political parties so that we can also have their views on that. Then another issue was whether Gambians in the diaspora should be given the opportunity to take part in the upcoming elections. This is an issue that I think needs really to be thoroughly looked into so that a final decision can be taken. That's why I am surprised that the IEC representative is not here. They should have been here to hear the concerns of political parties on this issue. And whether that is the election register, the final compilation of all voters should be made available at the request of any party in hard and soft copies without a cost. Whether the sum of $500,000 is paid as deposit by a presidential candidate is excessive or sufficient, taking into consideration that the person will lose the deposit if he or she doesn't attain 40% of the total votes cast. And then the other issue was whether death of an independent candidate should be a ground for postponement of an election or not, while same does not apply to political parties' candidates. Another issue was whether the voting period for presidential elections be from 8 a.m. to 5 p.m. or from 7 a.m. to 6 p.m. And should the transfer of place of registration be allowed in our electoral processes? And should there be any fee chargeable for such application? These were some of the areas that were put forward, or the concerns that were put forward when the committee divided and went on their outreach last week. Now, I cannot tell you the feedback we received from the communities, but it is on the records and we will reflect on it. But I thought we should just share that with you so that you will have an idea of what transpired when they went around the country. And then on that note, then, as I said, it was just to highlight the role of the political parties in relationship to the elections bill, and we have put across, indicated to you all the priority questions to political parties for their reaction and comments, observations, as was based on the questionnaire that the committee posed when they went on their tour. Now, may I, at this point, probably just before we proceed to the next item, allow the co-chair, maybe he has a few remarks, a statement to make before we proceed.
Thank you very much, Honorable Speaker, and the co-chair of the Joint Committee. Like she rightly alluded to, that was the approach we used when we were in the field, but it was not only limited to that. As you may be aware, the elections bill is a public document. We allowed people in the communities or in the respective public hearings apart from the few questions that we ask, to also give us their general thinking as far as the bill is concerned. Issues that they felt were not made mention or were not captured as per the questionnaires that we developed, and they feel it would be of use having it on board the elections bill. They were given the opportunity to air it out. So equally, that is what is expected from the political parties that are before us here. That is not only limited to this, but again, in your view, what you think is in the bill and you think it's not going to help in the process of registration all the way to the elections, you can highlight it. What you think is left out and is important to be part of the bill, you can also bring it forward. And that being said, at the end of our engagement, we will also expect every party to send us a position paper as far as the elections bill is concerned. It could be 1 page, 1.5 page, 10 pages. It depends on the information that you think would be relevant to the committee and help the committee in putting up our report for presentation at plenary. That's the addition I wanted to make. Thank you.
Thank you. Thank you very much. Now, honorable members, we have on the agenda, inviting the honorable members to put forward their questions or concerns. And then the next agenda item would be to invite political parties, one after each other, to state their observations, concerns. But I think it is neater to allow the political parties to raise their concerns, exactly, and then honorable members will come after that.
Indeed.
What do you think?
Yeah, it's in order.
Those in favor?
Yes.
Yes, okay, so we do it that way. May I now invite the political parties to state their observations, concerns, and comments on the bill? Yes, honorable member for...
The question here should make enough copies for them. I saw some of them struggling to write the question that you read before. They will make copies available to them.
Oh, okay.
In the interim aspect.
In the meantime, can you arrange for your the questionnaire to be printed, copied, and distributed? Or what we can we?
That's a question.
Can we? Sorry. FPAC is meeting. No, FPAC is not meeting today. The period, no, oh, sorry. Sorry, honorable members of FPAC. Knowing that we are meeting here, I had asked the clerk to send a message on the page, and also the vice president, together with the co-chair of the committee, FPAC PEG, so that they can shift, they push the meeting to around 12:30 to allow us time to at least consult further with the committee here and with the political parties before we join them.
Suleiman, who is going to make
Mr. Jallo, somebody gone? Okay, now honorable members, can we help? It's being done. All right, okay. Yes? Honorable Davo?
I want to suggest we follow the itinerary as it is. The members be allowed to ask the clarifications. Then later the political party reps can also ask the areas of concern that they feel were not treated.
Okay.
Otherwise, the members may not even have concerns today, because I want to believe that these concerns spotted by the members could equally be concerns of the political party. So let's have the members first to ask their questions. On top of that, if the political parties feel that there are other concerns that are not dealt with, they can also pose those questions.
No, but honorable, actually the consultation here is with the political parties. It's really with the political parties. I mean, either way it will be covered, but I just think that it's neater and proper for us to allow them, let them tell us their concerns, just like we did with the other stakeholders. We allowed them to give us an overview of the bill in terms of the A, B, and C, and then we raise our concerns. And it's a decision. It's not a personal decision, but it's the majority decision.
They feel this was the format we took. The public here, this was the format. And then here, the other stakeholders we are talking of, we do not prepare any question about those people.
maybe it was reduced into writing. Let us also realize that time is of the essence. So let us not waste time on these trivialities, because whatever happens, at the end of the day, honorable members will have an opportunity to raise concerns, but the primary concern here is from political parties. Yes, so I will, this time around, I will overrule. Let's take the concerns of the political parties. No, honorable, I have overruled them, and I'm going to also overrule you. Please, can we have, no. To be fair, let's be fair. A decision has already been taken, please. Yes. Can I start with the political parties on my right-hand side here? Pardon? Oh, they are not here. Okay, then we start with them. They're here, okay. Baggy, are you representing APRC? Okay, very well. Okay. PPP represent? No. You are? No? Start there. Okay, very well. Wherever. I mean, the important thing is just to allow them to start. Yes. Thank you very much. Please, the Secretariat, can you make sure that we...
My name is Mohammed regarding for the elections, I think all in all the committee will need to upload the committee on behalf of the party. Because I've gone through, since my arrival this morning, I've gone through a lot of the sections. And then on behalf of the party, it is okay with us. Just that when you go through some of the questionnaires, I was able to capture some from what you have gone through. In the case of the death of the independent candidate, I think it should apply on all sides, the parties and then the independent candidates, all the candidates. So in case there is a death or a person died before the election, we need to recheck that person once again. And then on behalf of the party also, I am suggesting that the voting period to give more time to the electorate to commence from the hour of 8 o'clock in the morning, let's say to 6 o'clock, to give more time to the people. And then the voter compilation also. I think IEC also should help us with that, the political parties, because it will do us good. When everything is compiled, we need to have that at our disposals. From there, the Gambia Action Party will also write a position paper on this issue. We will go to at the committee level to see. But from what I read, I think it is a good work, and then we should see this as a national interest, not on partisan basis. In doing that, we as a country and as a people will go forward. I thank you all for your kind attention.
Thank you very much. I'll see representatives of political parties who just came in. Am I right? Am I right? Representatives of political parties who came in for introduction, otherwise we proceed. Okay, let's proceed then. Next, well, I was calling you. Yes, it's just my introduction. Are you representing the political party?
Yes, yes.
Yes, so can you introduce yourself? We have already done the introduction, we went around.
Okay.
That's concern.
Yes, you are I'm just being very fair.
Yeah, I'm
Okay.
If your party stand is,
thank you.
If your party stand is, it has to be free. Then you said my last concern.
Are you representing your party or you're an observer? No, then no.
He's part of the committee. You have been seated this way.
He's a member of the committee, yes. This way.
That side is full.
Thank you. Please, can we proceed?
Yes. Please, one more. I just want to clarify one thing. My last, on the voter compilation, I think it should be free. On the political parties, yes. This is our suggestion, it should be free. And then it should be at our disposal. Thank you.
Any additional copies? Any proposal on additional copies?
Yes, that would do good.
At a cost?
No, not at a cost.
80 political parties.
Yes.
1, 3, or 4 copies.
Yes, but still.
I've seen the register. Anyway.
All right.
Yes.
No. No. It's not that?
Yes.
All right. Mr. Jai.
Initially, you will not take any question.
Please, next.
Next.
Yes.
No. Okay. To already fuzzy.
Pass the mic.
Honorable Minister, pass it this way, please. How you feel? No.
Yes. Okay.
Thank you very much, Madam Speaker. I want to thank the Joint Committee for inviting us here to share our opinion on a very important document. I was just talking to my colleague here. This is a very important process because this is the document that will guide us through our elections. So every party should attach importance to this. This is very, very important, and it's a very important process. Our views and our opinions need to be heard. So it's important that political parties take this seriously, because anything that goes beyond here, we may not have the opportunity to correct them. So it's important that we effectively participate in this process. Having said that, Honorable Speaker, the first question that was asked, whether IEC should receive donations or gifts, in the context of the act, what is the definition of a gift and a donation? Then we would be able to know whether even a grant from, say, United Nations Development Program or ECOWAS, or what constitutes a donation or a gift. If we know that, then we would be able to give a sound judgment on whether they should receive a donation or a gift. The second question, which borders on attestation, this is another very important matter. But I think already the provision that we have in the Act, which is Section 13, clearly indicates in the absence of this document, a birth certificate, a Gambian passport, national ID card, an attestation from an alcalo or sefo certifying he or she is a Gambian is sufficient. Because this, I believe, in accordance with the Local Government Act, these are our local authorities on the ground that are given the mandate and responsibility to act on behalf of the general citizenry at that level. So when you have an authority issuing an attestation, we believe should be true and representative. The issue of diaspora voting. Yes, this is another very important matter because the Constitution of the Gambia guarantees every Gambian to participate, either to be elected or to elect. So it's important that we take this into consideration. But of course, this goes at a cost. The resources available at our disposal. Regarding this forthcoming election, what time frame do we have to do the national registration process and allow IEC to go on to register Gambians abroad and allow them to participate in the electoral process. It is important that they participate, but also we need to give consideration what means do we have to do this. The deposit of $500,000, I think this is sufficient. For me, this is sufficient. $500,000 is a lot of money. When somebody pays that and he fails to achieve 40% of the total vote casted, I mean, that means that the person loses $500,000. For me, I believe that is enough. I'm talking on behalf of the NCP. That of an independent, well, as my colleague from GAP said, I think when we apply the rules should apply across the board. What is good for the Ganda is good for the goods. So I think it's important that we apply those rules. Transfer of voters. I think, yes, in certain circumstances, we find ourselves to move our, like myself, I am always registered at Central Badibu. And if I feel, transport going back and forth, I'm now resident in Sanementere. If I want to transfer my vote, would it cost me to transfer my vote? I think that right should be given to me. The mic is gone. I think that right should be given to me to the battery. But I think I'm loud enough. I think that right should be given to voters, but it must be guided. It must be guided to avoid duplication and double registration, which the Act already talked about. So those criteria should be well guided and developed so that the registration would not be duplicated. We also talked about election period. What the past experience has shown is that normally when you close polls by 5, then you still have a long queue. And sometimes in certain circumstances and certain regions, this brings conflicts. Because when IEC officers said, this is the time given to us, so those on the queue, you cannot vote. That obviously, that political parties will not accept this. So we have to go to the Act and make it clear that the stopping time, whoever it found on the queue should be given the time to vote. That will suffice. But for us to be able to be on the safe side, we open the polls early as 7 a.m. and close them by 6 p.m. This is what NCP is suggesting. But as suggested by Honorable Speaker, we will put something together and make observation on some of the articles in the Act. Like, for instance, I made an observation here. I need legal people to guide me because sometimes language may, for instance, you look at section 16, general and supplementary registration, and you look at subsection 4, it says the commission shall not conduct any registration of voters at least 6 months before the date scheduled for any election or referendum. So this, I need some clarification, at least 6 months. And now looking at the time frame that we have before this bill passed, it goes for the ascension by the president and it comes back to become law. What time frame do we have? So I think this is important. Thank you very much, Honorable Speaker.
Thank you. Thank you very much for those very useful suggestions. And please, members of the press,
Madam Chair, may I know whether we are simply supposed to react?
Who is,
Mr. Samsar, Samuel Sar, PDOIS. I would like to know whether we are supposed to react to the issues raised here. That is a priority question 8, or are we supposed to make any presentation? Pardon?
It's not exhaustive.
Yes, okay.
You are not to limit yourself.
Okay, all right.
What I said during my introduction
All right.
remarks was that a questionnaire was prepared when the two teams went upstate. So we just want to share those questionnaires with you. But you are at liberty to raise any concerns as far as the bill is concerned. So don't restrict yourself, just the bill. Feel free to raise any other issues. That's why you are being consulted.
Thank you very much.
Thank you.
I just...
Honorable Son, your questions were very pertinent. You raised a legal issue. Well, it's not for us to respond to that, but we refer it to the legal-minded people, the Minister of Justice. They will take it up. We will note every little concern that is raised, and it will be adequately addressed. Just by way of information, not just for you, but for all of us, we have our standing orders, and one of the clauses in the standing orders is the mandate and power of this joint committee to recommend amendments as they think fit. And that is why if you have any proposals, it will be discussed, and if there is need for that amendment, it will be incorporated. And that is why we always want to make sure that the Ministry of Justice and the IEC accompany us so that we will have their views on the issues of concern raised by political parties or any other relevant stakeholder or witness. That is why we are expecting the position paper. For instance, from NCP, not from what we are supposed they are representing political parties. They are not here as individuals. I think that's very obvious. It's obvious. I mean, he is not here as an individual. He is here representing a political party. So can we proceed?
Yes, I am representing a political party, and whatever I say here is the position of PDOIS. Thank you very much.
Thank you.
I would like to start by emphasizing that any bill, this election bill, has to be premised on the Constitution. And Section 1, subsection 2 of the Constitution vests sovereignty in the people, and any representative, like the government, should derive its authority to govern from the people. And in this regard, Section 26 gives right, of the Constitution, gives right to the people to participate in public affairs, including elections, the right to participate, that means the right to elect and be elected. And to facilitate this, Section 25 makes it a right to form associations, including political parties. And in this regard, to facilitate the exercise of such rights, Section 39 of the Constitution gives right, makes it a right for a citizen of the Gambia of sound mind and 18 years or above to vote in an election, presidential, National Assembly, council elections, as well as being entitled to be registered. It's very significant when we go through the bill to relate to these matters. There is the establishment of the IEC in order to be able to facilitate this process. And Section 60 deals with political parties in order to be able to do these matters. Now going to the bill itself, because occasionally there will be reference to the Constitution. When we go to the bill itself, and I'll start with the schedule. Schedule 1 is supposed to be premised on clauses 2 and 4. Schedule 1. I don't know whether you are with me. That's page 84. The fourth schedule.
The first schedule is at the bottom of, it starts from the bottom of 83.
Yes, okay.
So going to 84.
Yes. It says it's supposed to be premised on sections 2 and 4. But if you look at clause 4, that is not the case. It's dealing with a different matter. It appears to be clause 10. So it's important we take note of that. Yeah, Michael, yes. Schedule 5. Reference is clause or section 104, subsection 9. That's what it says. But that doesn't exist. 104 stops at subsection 5. I don't know whether you see it. Fifth schedule, page 118. Yes. Page 118. Yes. Rules published as subsidiary legislation. Schedule 6, which is dealing with the referendum, specifies the draft constitution, and it should actually really, in our own opinion, deal with referendum generally, rather than this specific draft constitution which was actually being tabled and rejected. It should deal with referendum generally. Now, if we go to the bill itself, the definition, let's say section 2, interpretation. Political party, page 7. where it says political party means an association of Gambian citizens organized to acquire and exercise political power and registered as such in accordance with this act. I think that is grossly inadequate because I didn't get into politics just merely to seek for political power and maybe become otherwise. It has to take into consideration maybe Section 103A of the current Elections Act. If one goes through that, one will be able to utilize part of it to include it in the definition as it goes over. That's Act number 7 of 2001.
Sorry to interrupt you. Maybe you can have
Right.
a proposed draft.
Yes. Will. Yes.
Have a look at it and also
Yes.
include it in your position.
Position, yes, we'll do that. Thank you very much. Yes.
Where it says political power, then can you explain to us what you understand by the term political power?
No, can you allow me to continue?
But we will have an opportunity to ask questions. Now we're engaging them, we're taking their concerns. Just let's note these things, and then when it is our turn to ask questions, then we will ask the relevant questions. Thank you.
There is also a definition here dealing with coalition. Maybe it's section 91 or something, or clause 91. I believe there should be clarification on what is meant by coalition. Are we referring to a merger? Are we referring to an alliance? There is need to be explicit in the definition. It only says coalition, and we leave it like that. It can be open to different interpretations. It's 105, okay. Furthermore, clause 4, conducting the nomination and election of candidates for the office, that's in clause 4, sub clause 2, conducting the nomination and election of candidates for the office of president, member of the National Assembly, mayor, etc., etc. The speaker is not included in this list, and our proposal is that the speaker should be included. Because in the Constitution, there is reference that this IEC is involved in the conduct of the election of the speaker of the National Assembly. So the speaker should be included in this. So clause 5 is referring to serious misconduct. In that's 3. Serious misconduct. B is talking about serious misconduct. D is referring to serious violation of any other law. One doesn't know what serious misconduct is, When is a misconduct serious? So there is need to be more explicit in this case to avoid any misinterpretation. And there is also reference to, that's in 4, where it talks about a medical board. That's understandable because there is infirmity of body or mind. But also there is talk of violation of the Constitution. There is talk of misconduct. So there will be need also, in addition to the medical board, a judicial tribunal, which can also play a role similar to that of the medical board. Clause 7. Definition of election officer is actually needed because one doesn't know, this is talking about appointments, that there is need to publish it in the Gazette, and if there are objections, they will be taken into account and there will be a review, and eventually a decision will be taken. But one doesn't know the scope of elections officers. It's defined, of course, in the interpretation, section 2 or clause 2, but does it cover like drivers, cleaners, etc.? So those things need to be taken into consideration as to what election officer actually means. It has to be explicit. Funds, well, the sovereignty of the Gambia is actually crucial. That's section in clause 9, which is dealing with funds. The sovereignty of the Gambia is actually crucial, and care must be taken as to when such funds, if at all, that is permissible, should be taken, because we should not actually sell our sovereignty because we actually need money in order to conduct elections. And it should, when it's talking about the different aspects, it should also include the disposal, the assets which have actually been disposed. All right. Clause 10. This one, the first one has gone to the extent of usurping the power of the Election Boundaries Commission, which is indicated in section 50 of the existing constitution. And that's why I was saying it's good that the bill be premised on the constitution. So this needs amendment to bring it in line with section 650 of the constitution, because that one is talking about an electoral boundaries commission, although it says under certain circumstances where the commission has not yet been established, the IEC can carry out demarcation of boundaries. But IEC cannot really just take it as its responsibility, because it's not its responsibility to do that work. So therefore this section should be rephrased to bring it in line with that proposal. Okay, and there seems to be a contradiction here with the registration of voters. What is actually required? That's clause 13, page 13. Clause 13, page 13. 4 items have been mentioned, and these 4 items are found in the Elections Act as amended. But if you go to Schedule 3, it includes 5 elders. So 5 items have been listed there, and the additional item is related to the elders. Our proposal is, let us stick to section 2, rather in clause 13 as it is, and that form in schedule 3, which includes 5 elders, that talk of 5 elders should be actually deleted. As a colleague said here, you have the local authorities who deal with these matters, and let's leave out others so that they do not influence the process of registration. Clause 15. I referred to clause 15, page 14. I earlier referred to section 39 of the Constitution. And clause 15 can only stand if section 39 of the Constitution is amended. So since section 39 of the Constitution subsists, then A of clause 15 has to be deleted. C, it's on page 14. C, because here it is saying serving a sentence of imprisonment. The Constitution does not make any restriction. It's saying if you are a Gambian of sound mind and you have 18 years, you have a right to vote. So we cannot come here and include this and say, well, if you are serving a sentence, that will be in violation of the Constitution. The Constitution wants every Gambian to exercise its right to vote, to determine the future of the country, to determine how the country is run. And nobody should be deprived of that, whether you're living in this country or you are abroad. Whether you are born in the Gambia or you are born abroad. So long as you're a Gambian, the Constitution says you have a right to vote. And you are entitled to be registered in a constituency. So A and C should go, and B, adjudged to be of unsound mind, full stop. The rest should go. Whether detained in a mental hospital, it doesn't say so. Adjudged to be of unsound mind, that is there in section 39 of the Constitution, so that can stay. If we go further, let's move on to 32. 32. Okay. Now 32, all right, before we go on to 32, in 16, he made a reference to that, in fact. That is, it said here, 16, let's still page 14. It's saying in 16, subsection 4, the Commission shall not conduct any registration of voters at least 6 months before the date scheduled for any election or referendum. Now, whether this should still stand as it is this time, we have to look at it very seriously, because registration will not be complete until the 11th of July. And that's less than 6 months before the presidential election. So that will, if we are to proceed with the election, that will create a problem, it will create a crisis. So this has to be reviewed. You know, either the timeline is reduced, or at least for the time being, it is not made part of this bill. That needs to be considered very seriously. And we should not, when we say 6 months, registration ends after 6 months, there are also other processes that take place. Appeals, objections. The revising court has to decide. It may go, there may be appeal to the High Court. So all these processes are in line, and it may take a longer time. It may be an additional month or more. So we have to consider all those things. And this matter, the best thing to do is to forget about it for the time being and it can be looked into later. Because I will not suggest that we postpone. We are not suggesting that the presidential election be postponed. Rather, we deal with this issue, maintain the same date as in the IEC calendar, and then move forward. Yes, there is also talk about continuous registration. What that means is not too clear to us. Still 16, it's still in 16. Continuous registration is referred to. So what that actually means is not clear. There is also talk of registration centers and registration, not registration, polling centers and polling stations. That area is a bit murky. It's not too clear as to what polling centers are and what polling stations are. And there is interchange, continuous use. I can't remember which clause, but it's there. So that needs to be reviewed and then become more explicit for us to understand and know what we are required to do. Let's go now to 32, 33. Objections. Now the registration is complete and people may object to certain names being on the register of voters. And it is significant that the fees to be charged is left with the IEC. The IEC, who by regulation should indicate what the fees should be. So it's not specified. Our view is that the fee charge should be reasonable so that you don't make it so that it becomes affordable for anybody who is objecting. Suppose you have about 100 people who have been wrongly registered. So if the fee is high, in the section, so that we do not give the IEC that much latitude just to charge any fee. Okay, now if we look at 17 and 40, if we compare the two, 17 and 14, the arithmetic doesn't seem to work. 17 and 14. 17.1. At any time before a general election, a registered voter who is resident in an electoral division other than that in which he or she is registered for not less than 2 months may apply to the returning officer of the where he or she is resident for his or her name to be entered or transferred. No, that's not the one. It must be 2. Okay, any application under subsection 1 shall be made not less than 21 days before the last day of nomination. 21 days before the last day of nomination. To the constituency where the applicant is resident, where the application relates to nomination, or made not less than 90 days before election. And notices for election come this while, if you go to 40, this is 90 days. Let's go to 40, you see. 40 is saying, that's 2. The notice referred to in subsection 1, that is notice of an election, shall state the date which shall not be less than 30 days after the publication of the notice and the place of nomination of candidates, the date on which or the dates between which as may be appropriate. No. So here you're talking about 30 days. If you add it to the notice for nomination, it's less than 90. So that needs to be, the arithmetic anyway doesn't seem to work out. 43. 43, our position is that the deposits which were agreed upon by the National Assembly in 2018 when they amended the 2016 elections the Elections Act. So they simply returned to the previous fees. That is $10,000 for a presidential candidate, $5,000 for a National Assembly candidate, $2,500 for a mayoral candidate, and $1,250 for candidate for council. So our position is that these fees should be maintained. Fees for elections should not be forbidden to candidates, and they are quite reasonable, and they should be left as they are in the Act. That's what exists in the Elections Act, and that our recommendation is that that is what we should go with. Let's go to 51. 51, what subsection? It's dealing with the withdrawal of candidature. Well, it's saying 3 months, not later than 3 months before the date. Oh, well, let me read the whole thing. A candidate may withdraw from his or her candidature by notice in writing, signed by him or her, and delivered by himself or herself, or one of the persons nominating him or her to the returning officer, not later than 3 months before the date of election. Here too the arithmetic does not work. Our proposal is 7 days. 7 days before the date of election. Because we are talking about nomination being between the date between nomination and election being 21 days, at most minimum 6 days. So if you have 3 months, that's outside even nomination. So how can you talk about withdrawal? Our proposal is it should be 7 days, and we further propose that the date between nomination and election be 1 month to give political parties adequate time to campaign. We go on to 55. Well, I've already dealt with that. There's polling centers and polling stations. 60. All right. We have decided to be a little bit innovative. We don't know whether that's acceptable, but rather than merely polling agents, we can have polling supervisors. Polling supervisors in cases where candidates do not have adequate polling agents to cover all places, or even where they have adequate polling agents to cover all polling stations. Sometimes you do have failure in terms of appearance. So our proposal is to include, of course, all these things, as Madam Chair was is proposing is that we should have a position paper. That will be done and it will be included there. Our proposal is to have a polling supervisor who will be allowed at the polling station and can replace a polling agent who has failed to appear. So that's food for thought. We go on to 65. Our proposal regarding the time of opening and closure of polls is that so long as it's a public holiday, we don't have problem with the time. It can still be maintained between 8 a.m. and 5 p.m. But if it is not going to be a public holiday, and there is nothing in the bill here suggesting that elections should be the day of election should be a public holiday. Nothing suggests that here. So we are working on the good faith or the goodwill of the executive deciding whether to declare a public holiday or not. It's a practice which has been going on. So, but if it is, our view is that so long as it's a public holiday, in which case it should be included in the bill, then between 8 a.m. and 5 p.m. is okay. Otherwise, we suggest 7 a.m. to 7 p.m. This will give time to people who have gone to work to come and vote when they close from work, or those who close late from work to rush to the polling station at 7 a.m. and vote before going to work. We must really work from the principle, because when I was not trying to be idle when I quoted that sovereignty resides on the people, and the people have the right to vote and participate in elections. These are rights. They are sovereign, and government derive their authority from the sovereignty of the people. So in that case, we should always ensure that citizens' right to vote is protected. We should endeavor to see that every citizen has the opportunity to go and vote, and there should be no stumbling block. And this is why we are totally opposed to postponing the registration of Gambians living abroad. We are totally opposed to the registration, rather postponement of registration of Gambians living abroad. The IEC, the government should endeavor to ensure that the funds are provided, and that, for example, there is $54 million by National Assembly members. Maybe they can consider forgetting that, to ensure that that amount which is available can be utilized for that particular purpose. But the issue is that all those concerned should endeavor that the Gambians, our fellow Gambians abroad, in the diaspora, are not deprived of their right to vote. All these years, they have been deprived of their right to vote. It was in the 1997 Constitution. It was there just like that. And nothing was done to ensure that they voted. Now, they supported change. And they were hoping that this time they will be able to exercise their right to vote. So we should endeavor, the bill should, there's nothing, I think the question is right, should they should they be given the right to vote? Is there in the Constitution? He says you have the right to vote. So that's not the right question. It's what is going to be done to ensure that they exercise their right to vote. That's the correct question. And I hope efforts will be made by both the IEC and the government to ensure that Gambians abroad who contribute $187 million annually to the coffers of relatives, etc., in the Gambia should be given that right. They should not be deprived that right. We've gone to 66. Yes?
Sorry, sorry to interrupt you.
Yeah.
There's a vehicle registration number BJL 1492. Can you want to just move it so that the vehicle can move? BJL 1492. Thank you. Yes, Honorable.
Yes.
I want to observe if we can have time for participation. At least there are going to be opportunity to have
Yes.
If there is a time, then we fast track on that.
That's the proposal. Are you going clause by clause? If we're to,
well, you can give me time, whatever this is, I go by that.
do we allocate the time? As was said, and we all know this is a very important engagement, and every proposal, suggestion matters. So, Honorable Cisse, what do you say?
We should do it at this time. Already, the gentleman has taken a lot of time. Maybe if we have others.
Let us weigh it. The two gentlemen who spoke previously really did not take that long. I think they took less than 15-20 minutes. So we can, let's allow them. Just try to summarize where you can.
Okay, yes. Thank you. Very quickly, maybe I'll try and finish within 10 minutes. All right. Yes, so 86. Yes, no, 66 is a technical, it's not practical. That's signing of the voter's card that the presiding officer should. It's not practical because of the nature of the card. So the presiding officer cannot sign. Yes, 86, that's what I was saying. I'm skipping some, but 82 is talking about transmission. This is very important to us. 82, that's transmission of a result. First, we are of the opinion that every polling agent should be given a copy of the result. And then secondly, also, the transmission of the result, with the development of technology, we believe that every candidate can be given the results, say, through WhatsApp. For example, that's transmission. You transmit the same result to the headquarters, but ensure that every candidate gets the result through WhatsApp. So WhatsApp numbers can be taken before the polling, and then the candidates will get it. And we go on then, very quickly. Okay, section of clause 92D. 92D. Yes. Yes. Okay. Yes. Okay. Fine. 92D. So it doesn't have D. We are the ones proposing D. No, 92. 92, which is dealing with prohibitions during election campaign.
Okay.
Yes. Our proposal that it should include civil servants who by virtue of their position are using their position to support political parties. That is, they use their position to support political parties. So that should be D, so that it's prohibited. So 93.1, it should be, okay, we can include that in the, all right, 102, yes, 102 is significant. It's talking, that's the one which is dealing with referendum. Referendum, no, it's not 102, it's 131. 131. Yes, referendum question and notice of referendum. Section 102 of the Constitution makes provision for referendum. That means if at all the members of the National Assembly are dealing with an issue, a bill is brought and an issue arises, the members of the National Assembly can propose a referendum, and the Speaker is involved in the process. Otherwise, it's through amendment of the Constitution itself, which is provided in Section 226. So, Section 131 does not speak the language of the Constitution, and therefore it needs to be reviewed to bring it in line with the Constitution. And the same applies to 140. It says, the result of the referendum shall be determined by a simple majority. Again, this does not speak the language of the Constitution. If you go to Section 226, it's saying something different. So that too needs to be reviewed to bring it in line with the Constitution. 142, finally. Referendum may be of interest to civil society. And we feel that polling agents can include the IPC and the CSO. The IEC cannot be a polling agent. We're saying IEC appoints polling agents. We feel that is inappropriate. The IEC conducting elections and appointing its own polling agents, no. So we can leave that to the IPC and civil society. I think there is something like the coalition of civil society on matters related to election. Thank you very much. Thanks for the patience. Thank you.
Thank you very much. As for our party, we would love to be given more time so that we can talk with our party members and executives so that we write to you people our position paper and give it to you as of the date you require. Thank you very much. Our party is Gambia Party for Democracy and Progress. Thank you. As per the time given by the committee.
Thank you very much. I want to also say, let's avoid asking direct questions. Let's put our questions through the chair. If you want to share any concern, please take permission from the chair so that it's orderly. So we've had you, DPDP. All we want to say is the sooner you do it, the better. Precisely if you can get it here against Friday, because the consultation is going on, and we hope to wrap up the consultation by Friday.
Thank you very much.
Thank you very much. I am Amaduka from the Gambia Democratic Congress. And with regards to the bill, I will try as much as possible again to save time. And then on section 9, 1C, which talks about the funds, estimates, accounts, and audits. The funds of the commission shall consist of monies appropriated to it by the National Assembly, fees and charges levied by the commission, and C, which of a great interest to us, such grants or donation as may be made to it, provided it does not compromise the impartiality or independence of the commission. In that case, the issue of impartiality, what is going to be regarded as being impartial, who's going to determine that, and so on, is very key. So I believe we as a party, there is nothing that is more sacred than our electoral process. And then I think, and so we as a party believe that the funding of the IEC should stop, on monies appropriated by the National Assembly, and then fees and charges levied by the Commission, and not grants or donation from third parties. On page 13 of section 14, we talks about the registration of Gambians living abroad. We just have a similar opinion with that of the previous speakers, that the Gambians that are abroad are citizens granted the right to vote by the Constitution of the Gambia. So we must endeavor through the IEC and government to make sure that that right is given to them. It shouldn't be questioned in any way. So they should vote, and then whatever that must be done to facilitate that to happen, because they participate in the electoral process, they participate in every act, every bit and piece of the electoral campaign and all of that, and they contribute heavily to our development as a nation. So therefore, they should be given the right, the due to vote, especially in these coming elections. And thirdly, that's section 37, page 25, 2B, which talks about provision of master register and master supplementary register to all political parties in soft copies. Yes, the IEC is supposed to provide that to all political parties. And when it comes to the issue of the hard copy, at least one, the IEC must prepare and hand over to political parties without any cost to political parties. Because it is important that both the hard and soft copy come from the IEC, and then the hard copy be stamped and authenticated by the IEC and to be handed over to political parties. Because the document is going to be very important to political parties, in our respective work in our offices. So therefore, at least a copy should be provided by the IEC, a hard copy, which is going to be free to political parties. So we should not have to pay for that one. In case political parties need supplementary hard copies, then political parties can take the burden of that cost. But at least one should be handed to political parties by the IEC and authenticated by the IEC. Also, on page section 44, that's page 30, return and forfeiture of deposit. A deposit paid in accordance with section 43 shall be returned to the candidate if, when you come to D, in a contested election in relation to the election of a president, he or she obtains at least 40% of the valid votes. Under normal circumstances, such percentage should possibly be higher than the number of votes the person need to win the election. the situation we have in place, somebody can win election by 20% of the votes casted. So why would we require that person or that political party also? We shouldn't have a situation where we are asking the people to actually need to have number of votes that are higher than the possible votes that they can have to win the elections. So I think that needs to be revisited and reduced as much as possible. Probably we may say not all funds can be returned to political parties, but we can talk about maybe 15% or 20% at most. But there is a possibility that a political party can win the election, the president election with 20% of the votes casted, and then we're asking that to get a refund of their funds need to have 40% of the total votes cast. So I think that's the add up with us as well. So that needs to be reviewed and reduced significantly so that we will leave a gap, at least that there is a possibility that the number of votes that candidates are going to have to win the election is higher than this percentage we're talking about, that to get their deposit back. Yes, and then on section 33. Yes, section 54, death of a candidate. If after the date appointed for the receipt of nomination, one of the candidates nominated for election to an office dies before the poll has commenced, the returning officer shall notify the fact of the death to the commission, which shall cause a fresh notice to be published in accordance with the section 40. In respect of the electoral division affected by the death, provided that the death occurs within that period, postpone the holding of election in respect of the electoral division affected by the death if the death occurs outside the period stipulated in section 51. So we talk about the death of independent candidate. I think it should apply the same way, it should apply to both independent candidates. But my issue here is, it is important. We can have, in a situation where we have two, like in a second round of voting, we have two people going in for elections. And then unfortunately one happened to die within that period. I think the people should deserve the right to maybe for elections to hold. I'm just trying to say we must as much as possible to avoid electing people by default. So in a situation where everybody is significant, when one of the contestants dies before elections, I think that should warrant the election to be postponed, be a party a candidate or an independent candidate. Or at least investigations need to be taken up to see and to establish the reasons or what might have caused the death of that person. So that is something that we need to consider also again. And when it comes to the publication of results, the chairperson or the vice chairperson shall be the returning officer to announce the results of election, and in their absence, the commission shall use its discretion to choose a returning officer. I think we as a party believe it should be incumbent upon the chairman of the IEC to declare election results. And then in case of incapacity of that chair, then the declaration might be moved to a different body from the IEC, probably the court or the High Court, which maybe, if it is the High Court, appeals can be made to the Supreme Court. But having alternates, with the responsibility to declare in the same office at the IEC may not be ideal with us. So therefore we may propose as a political party that the chairman of the IEC should be the person with the authority to declare the election results. And then prohibition, that's 92, prohibition during election campaigns. In B, we believe that no political party should be able to use state resources, for political propaganda and purposes. So we're saying that abuse or engage in the improper use. Political parties should not be at liberty to use state resources, being proper or improper. That needs to be revisited, because if there will be a chance for political parties to use state resources, then there should be a provision to provide that same opportunity to all political parties across. So no political parties should be able to use state resources for their electoral process unless otherwise provided, or the similar same opportunity be provided to all political parties. A document that's on, we talk about the third schedule, Form 1, on page 92. When it comes to the issuance of attestation, I think we talked about, the issue of the birth certificate, Gambian personal identity, but a document certified by 5 elders that the applicant is a citizen of the Gambia. I think that is still important, it's still necessary, especially in the local area. Yes, could be some complication maybe in the cities, but also in the local areas, in the very remote areas, it is important that this certification happen. This, I think, will just make people to trust the process more and more. We have seen alcaldes and sefos taking part in the political dispensation in this country. And I think, therefore, that being the case, just to be very honest, unfortunately, just 2 days ago, I've witnessed a similar scenario where an alcalde was telling people that they need to avoid going against, the government or so. So that being the case, it is important that we still have or maintain these 5 elders in the process. I think it just makes the process more trustworthy. So we as a party believe that this can be maintained in the process to the issuance of attestations to citizens. And then finally, we also as a political party will come up with a position paper. And then I would also suggest one other issue, that is the issue of the deposit for presidential candidates that had been revised before, and then if it has to be changed again, then it will raise questions about the significance and the reasons why it was revised not long ago. So asking political parties and then independent candidates to deposit 500,000 to exercise something that is a right is exorbitant. And I think some other way it is putting pressure on political parties and independent candidates, to lobby for funds from, areas or angles that, some may question. So I think it should be maintained to, as it was revised not long ago, 500,000 to be deposited is too much. It's too much. And then also I'll just finally advise, usually the inter-party committee can play a big role, especially when political parties are supposed to engage with the members of the National Assembly. The inter-party committee had a position paper on all of these issues before. It was worked out, taking many days, and then a position paper was made by the inter-party committee that has talked about most of these issues. So it was sent to the respective authorities. I'm not sure of the National Assembly though, but it was sent to the government and the IEC. So, for reference purposes in the future, the inter-party committee can play significantly because their political parties on all of these issues can have an agreement and understanding, come up with a position paper, and that position paper will represent all of us. Thank you very much.
Thank you very much. Can we have JF?
Yes.
Yes, JF.
Thank you very much, Mr. Chair. And also thank you for giving us the opportunity to come up with our position paper. However, I would like to highlight a few areas that may be important for my colleagues and also your committee. Okay. Section 4 and paragraph F. This deals with the powers of and functions of the Commission, IEC. Paragraph F, the registration and supervision of political parties. It is our considered view that it may be better if we replace supervision with guidance or regulation, because supervision appears to be too embracing. That is our observation.
Sorry, honorable member wants to observe.
Okay.
I think he said section 4. You said section 4, right?
Yeah, page 8.
Paragraph F.
Yeah, page 8.
There is no F in section 4. There is 2F.
Oh.
Section 4, paragraph F.
2F, yes, 2F. Okay, I'm sorry. 2F, yes. So we are proposing that the word supervision be replaced with guidance or regulation, because supervision appears to be too embracing. Then page 25, section 36, continuation of existing head and supplementary registers. So perhaps I would need clarification on this issue, because I'm trying to foresee a situation where, for one reason or the other, the registration of voters could not go ahead as planned. And does this mean we'll be stuck with the present registration of register of voters?
Just raise the issue.
Yeah, that's the issue. Yeah.
We are hearing you.
Yeah.
We'll find out.
Yeah. Thank you. Then okay, page 35, relating to that of an independent candidate. Our fear is if this section or subsection is maintained as it is, it will discriminate against independent candidates. So therefore, there is need to look at this so that there is no discrimination in the treatment of candidates. Okay, on page 29, subsection 5, where it is stated that a candidate who enters or procures the entry of the name of a voter,
What page?
page 29, page 29, yeah. To be a supporter of the candidate, nominate him, and then turn around and accuse the candidate for improperly obtaining his support. So this needs to be looked at so that the procedure will make sure that the those nominating get their nominations recorded properly so that they cannot turn around and accuse the candidate for falsely, yeah. On page 30, section 44 and part of I, DI, the elections of a president, he or she obtains at least 40% of the valid vote. I think this is, the threshold is too high. The threshold is too high because we are talking of 18 political parties. 18 political parties, you divide 100 by 18, perhaps a winning candidate may end up scoring 25%. So are we saying that the winning candidate will have to forfeit his deposit? So this has already been highlighted by my colleague next to me. So okay. Page 32, section 48, civil servants are left out because you talk about judges, members of the armed forces, police, alikalos, safos, members of the commission, civil servant. How about civil servants? We believe there should be part D to add civil servant.
You can use your mic now. I think the system is back.
Okay, where is the mic? Okay. Oh, yeah, okay. Even this one is working, so thank you. On page, oh, okay, I've already. Okay, on page 40, section 64C, it says place the ballot box in an open place of the polling station and keep it sealed until the close of the day. Perhaps we, when this is drafted, I think the drafters are thinking in terms of ballot papers, because if it is token, you cannot leave ballot boxes in open places. So I think this needs to be looked at. So, Mr. Chair or Chairman, Co-Chair, these are the observations, and we will elaborate on them in our position paper. Thank you.
Thank you so much. Can we have the next party, United Democratic Party?
Let me express profound gratitude to this joint committee for inviting us to share with you our views on the draft bill, which is headed 2020, but we are discussing 2021. And I believe maybe there will be some textual amendments to cater for that. The Chairman, my observations, some will relate to matters of drafting issues, and others to see the internal disharmonies in the draft. And of course, whilst I do that, I'll also take opportunity to maybe advert very briefly to the issues that have been raised, and to say that we will certainly submit a position paper, because I do not want to deal with all the issues that I have put here. Otherwise, others may not have the opportunity to really make their own presentation. First, Mr. Chairman, I just want to refer to the definition clause, that is clause 2. The definition of the Constitution says, Constitution means the Constitution of the Republic of the Gambia, 1997. Mr. Chairman, I believe that this definition does not take into account the possibility, the very high possibility, that the 1997 Constitution will be replaced by another Constitution in the very near future. It may not be in 2021, but certainly could be before 2026. So we would suggest that Constitution be defined as the Constitution of the Republic of the Gambia for the time being in force, so that whatever date and the Constitution comes in, it will be taken care of. And the application of the Act, Clause 3, Subclause 1, Paragraph A. The application of the Act says it applies to election of candidates for the office of President, member of the National Assembly, mayor, chairperson, councillor, and such other offices as the Commission may prescribe by order published in the Gazette. My first observation on that, Mr. Chairman, is that maybe to lessen use of words, because you go to the Local Government Act, it defines mayor, and say that also includes chairperson. So I don't know whether, from drafting point of view, reduce, unburden the draft bill. But most importantly is the last bit of it. And such other offices as the Commission may prescribe by order published in the Gazette. Mr. Chairman, I think this will be arrogated to the Commission, that is the IEC, the power to declare which office and which offices are not elective. I think this should be the prerogative of the National Assembly, that is, the positions that should be elected should be one determined by the National Assembly, or at least by an act of the National Assembly, not by the Commission to issue orders. So if the Commission issues orders that there must be election of a safe hold, when the Constitution does not provide for it, the Act of National Assembly does not provide it. So it would be contrary to our existing laws. So I would suggest that those last words and such other offices as the Commission may prescribe by order published in the Gazette be deleted. You have this repeated in other clauses, and I would say that, I don't want to go to it, but I would say that wherever it appears, that it be deleted. Because we see it in clause 4, subclause 2C. So this should be deleted. Well, anyway, that's a drafting issue, that's not very important. Clause 5.3, I think that has been referred to by Mr. Sir. Talks of serious misconduct, violation of the Constitution, serious violation of any other law, or bankruptcy. Now, these are matters that really call for investigation into the character, integrity of the Chief Electoral Officer. Now, we do not want to put them on the same level as the Commission, where you would have to establish a tribunal to investigate into the allegations, any of the allegations that may be made against them. But certainly, I think it would really do good if you try to give an indication of what constitutes serious violation of any other law. And in determining that, should just the electoral officer be removed without any due process? And due process here, I do not really mean that the establishment of a tribunal, but certainly it could be through a disciplinary committee that could be constituted, because you are making very, very serious allegations against a person whose conduct has not been an issue at the time of his appointment. And having been appointed, you make allegations of misconduct on his part, and his integrity, his reputation is at stake. So I would suggest that a disciplinary committee should be established, just as it would deal with any employee. With the Ports Authority, an employee in the civil service, before the service are dispensed with, they are then given this fair trial. And of course, talking to that subclause 3, I think the reference to subsection 4 in the next clause is certainly a mistake. I think it's a reference to subsection 3. You know, it says notwithstanding subsection 4. It should be a reference to subsection 3. Now, clause clause 7, clause 7.4. Clause 7.4, again, this probably a drafting thing. Subclause 4 says, where the commission did not receive an objection in accordance with this section, it may confirm an appointment. But then, but where do the commission receives an objection, and the objection has been considered and yet not upheld? So we should factor in that where an objection has been received and the commission duly considers such objection and finds no merit in it, then the appointment should be confirmed. Now, there is this vexed question of grants that we are all concerned that we want the IEC to be an institution that is controlled by no one, that is not being made to really serve any purpose other than conducting its affairs in an impartial manner. We would suggest, Mr. Chairman, that the IEC should, where they receive, or where it is proposed to give us a grant, disclose the identity of the grantor or the donor to the IPAC, because we are expressing these concerns here because we are political parties, and we believe that if the IEC receives grants from source of some other sources, they will probably favor the grantor or the donor. But with the identity of the donor and grantor disclosed to the IPAC, they can make informed decision and agree with IEC that this really is grants and grants and donations that you should receive. Otherwise, let us say the Westminster Foundation for Democracy, should the IEC not receive funds from them in their aid? After all, we have in the past been receiving aid from our international partners. So when you say that you do not want them to receive any funds, in fact, I hear someone say about even mentioning UNDP. Why shouldn't we? After all, I mean, it is their integrity. I'm sure the IEC will not soil their integrity for accepting to receive donation or grants from United Democratic Party. Because if United Democratic Party gives donation or grants to the IEC, it will be impliedly telling IEC, look, I'm your good friend, take care of me. But then, independent institutions, and that's why I'm saying that let the identity of the donor be disclosed, and then we can go ahead. Now, clause 13, in fact, yeah. Oh, no, clause 10. Again, this, I believe, it's a drafting issue. Says the Commission shall, for the purpose of registration of voters and the conduct of elections or referendum, divide the Gambia into the administrative areas specified in Part 1 of the first schedule, or any other law. Now, I'm troubled by this any other law, because I think the first schedule really takes care of the boundaries of the various boundaries. So I believe that the words or any other law is probably a tautology and should really be deleted. And clause 13. Clause 13 really we talk of registration, qualification for registration, and indeed for registration in a foreign country. Mr. Chairman, Co-Chair, I want to make this appeal that the law should just not be made and expressing positions when in fact what is entailed in the law, what is espoused in the law is not being implemented. It's as good as not making any provision for it. You cannot make provision for registration of Gambians residents in a foreign country, and in fact making it a qualification for registration. Have it those in your laws, and then turn around and not giving them the opportunity to really avail themselves of the benefit of that law. I don't think it is right. I mean, the issue of the Gambians resident abroad to be registered was an issue that was made clear at least 2 years ago. Everyone knew that this is what is on. The issue of the countries abroad have not been demarcated into constituencies. Of course, we all know what is in the Constitution, Section 39. Both IEC, Ministry of Justice, and political parties, that constituencies have to be demarcated. And they cannot now say, because the foreign country has no demarcation of constituencies in the foreign country, they cannot vote. After all, government has accepted that the diaspora is the 8th region. Now, according to the schedule here, you have 7 regions. So the diaspora, being the 8th region, should be the 8th administration as was within this 8th region. Europe proper could be considered as a ward. That is Germany, France, Italy, Spain, Holland. The Nordic countries in a ward within that 8th region. The United States of America, you have the East Coast, the West Coast, and the South. Can have them as regions. And for Africa, you certainly can have the 3 countries, or for the countries in West Africa, as the ECOWAS country, as another ward. So the issue of not having the constituencies demarcated for me is not an answer. There has to be the political will. And which is a question of funding, your committee can bring this to the National Assembly. Let there be an appropriation bill, a supplementary appropriation bill. We have had supplementary appropriation bills to fund things. So we have to invest in our democracy. The Gambians in the diaspora have been contributing and continue to contribute significantly to the economy of this country. And if they do so, they should have a say in the government that governs the affairs of this country. And the only way that this can happen is to really to extend the franchise to them. We should not put this in the laws, and then it's there as the one of people would say, Mabel, for absolutely serving no purpose. So let it be given the teeth to bite. So I suggest, Mr. Chairman, that this registration of foreigners in the Gambians in a foreign country should go along with really giving them the opportunity to vote. There is this subclause 3, which deals with the before that, let me deal with the subclause 2 of clause 13. An attestation from an alcalo or CFO certifying that he or she is a Gambian. Mr. Chairman, I agree that attestations in the past have been subject to abuse. There is need to have them controlled. Because really, doing away with attestation completely would disenfranchise quite a number of people. But what I do not agree with, and I do not support, is that the CFO should be one of the persons to attest. Now, take for instance, I'll take Fuladu. The CFO is somewhere in Daru. How does he know that Mr. A, in fact, was born in Solodo? You know that, I mean, half the villages, you know, I mean, in Kiam, yeah, the CFO is somewhere, you know, inside there. How does he know that the person was born in Dubudu? But alcalos are well positioned to know who is and who is not born, who was and who was not born in their villages. They are CFO, of course, in the village in which he resides. Maybe yes, but not for not for every village in the district. I mean, he'll just be stamping, you know, without really, in his own conscience, knowing that this person is a citizen of the Gambia. So we would really we would suggest that we do away with the CFO. But even with the retention of attestation from an alcalde only, we suggest that what was in the pre-1994 Elections Act be brought back in, so that the registered officers would have an opportunity to interview the claimant with an ID card and a passport. Maybe that's okay. But then you should be interviewed so that your claim as Gambian would really be substantiated. Therefore, you can go to the alcalde, he stamps a document that you are a citizen of that village, and when you are interviewed, certain questions being put to you will just show that in fact you are not born in that village. So the interview mechanism, I think, should come back, and that in fact that would really give the IEC control over the registration process. But if you say that any document presented, it cannot be rejected. With birth certificates, yeah, in many instances, birth certificates are evidence of place of birth, not evidence of citizenship. It's certainly not evidence of citizenship. Yeah, I mean, my daughter has children, you know, in UK. They have birth certificates. If you received to them, but then they are not citizens of the United Kingdom. Senegalese comes here. His wife gives birth to a child here. Can take a birth certificate to show that he was born in this place on this particular day. But it's certainly not evidence of citizenship. And I think these are the issues that we want to really, because since we want to make sure that our electoral process is not subject to abuse. We just want to Gambians to take part in the election of their leaders and representatives in National Assembly. We have to be careful that non-citizens should not get registered through some dubious documents. We know that Gambian passports and Gambian identity cards. We know that people have had access to them who are not Gambians. So I invite the committee to really bring on that issue. Now, on registration, I think it has been mentioned that continuous registration of voters. I am also not sure what continuous registration of voters is. When there's provisions in the draft that says that the IEC will declare periods within which registration will take place and indicate the registration centers. Now, if you have a continuous registration process, that does not rhyme with that authority of the IEC to declare periods to to clerk period for registration. We have clause 15 on the issue of entering or retaining a person's name on the register of voters if he or she is serving a sentence of imprisonment. I don't have any problem with entering, because entering, if you are serving a sentence of imprisonment. I remember this was an issue that the CRC, teased Gambians with, whether a person who is serving a sentence of prison, whether they should be registered as voters. It was one of their issue papers. Now, there are logistical problems. I mean, go to a prison to register anyone. If under this provision, a person serving a sentence of imprisonment is entitled to have his or her name on the register of voters, then you are imposed an obligation on the IEC to go to the prisons and register persons serving sentences. What I think should be entertained is to have the person to have his name retained on a register of voters. Now, on the 29th of May, Mr. X registers as a voter. On the 5th of July, on the 5th of June, he is convicted and taken to prison. Should that be a reason why his name should not be retained on the register of voters? After all, he may, before the elections, appeal against his conviction, and it will be allowed. So what I would suggest is that the words "or retained" should be really deleted, so that anyone who has his name on the voter register before his conviction should be entitled to have it retained. After all, there are other elections that could take place, even not presidential elections, which would find him out of the prisons, and then he will be entitled to vote. Now, Mr. Chairman, let me. I don't want to take too much. We'll put the others in our position paper. But there's one very fundamental one: election petitions. Election petitions. It talks of you cannot question the election of a president except by a petition filed in the Supreme Court, and then election of a member of the National Assembly except by petition filed in the High Court. 98. Yeah. Clause 98. Mr. Chairman, I see that there is a conflict between. Is it section 98? No. No, it's section 101. 101, clause 101. Clause 101. Yeah, clause 101. Yeah. An election petition shall be tried by the Supreme Court in the case of an election to the office of the President, and be the High Court in the case of an election to any other office. And I believe this to any other office includes the office of the National Assembly. But section 127, I think paragraph C of the Constitution provides that the Supreme Court shall have original jurisdiction to try cases where the issue of election of the president is contested, or whether a member of the National Assembly has validly vacated his seat or has been validly elected. So this is in conflict with the. This is in conflict. Is it? No, I think it's 127. It's 127, original jurisdiction. Huh? I think it's 127. Yeah. So this provision here is in conflict with that. So I think we don't want to pass this, and then somebody goes to court and say, look, you shouldn't do that. Now, what I want to finally state, and then we'll leave the rest to our positions, is the termination of fees. Deposits. Yes. In the first place, the 500,000, we do not know the proposals, because I mean, the proposals what informed their opinion in having it at 500,000. We do not know. So certainly, whatever the position might be, we believe that the 40%, the forfeiture, 40%, I think that is a mistake. In the old, well, not old, in the current election bill, I think if you fail to secure 25% of the votes of the winner, so it's not the valid votes cast, it's related to the person who has won the elections. It cannot be otherwise, because otherwise, really, in the present situation, there is no candidate who will get 40%. But then, the winning candidate, you will lose your deposit if you do not secure at least 25% of the votes cast in his favor. And I think that should be what is there. But I think the legal counsel can look at the IEC, can look at the current and harmonize it with that. Then the clause 151, subclause 2A and B, arrogate to the IEC the power to make rules generally for AB. We already know, and we have seen, that it is National Assembly that has determined the fees for registration of political parties. The National Assembly has determined, or at least it is proposed, that the National Assembly determines the fees for deposits. In the current legislation, it is the National Assembly that has determined the deposits. You cannot take that away from the National Assembly and give it to an implementing authority. If there has to be any change of fees, whether upward or downwards, it should be the prerogative of the National Assembly, not the Commission. So I would suggest that paragraph A and B of clause 151, subclause 2, be deleted. And maybe I should talk about this. There's the 5th schedule on the nomination. You see that there is a clause, Form 1 of Part A of the 4th schedule, choice of Vice President. Now, in the body of the Act, there is no mention of a running mate, unless this is thought to be brought in. But otherwise, you start asking yourself, where does, on the schedule, where does the choice of a vice president, where does it derive its authority from? But in any case, we believe that making it mandatory to choose a vice presidential candidate could lead to some problems. I want to recall our neighbors, Nigeria. We know Abubakar Atiku was Atiku Abubakar was the running mate of President Obasanjo. And after the elections, for some reason or the other, relationship soured to an extent that the government machinery in Nigeria, was so stalled, was coming to a halt. They had to go to court. Obasanjo removed him from cabinet, and they had to go to court and say, you cannot, because he was elected on the same ticket as you. But then the uneasy relationship continued. And that does not do well for the smooth running of the government. And indeed, the current constitution provides that where the president vacates, the vice president takes over. And indeed, the constitution or at least the constitution that has been proposed does provide that it is only within 1 year of the expiry of the term of the president that he can hand over to his vice. Otherwise, if the office becomes vacant, there has to be an election, by-election to fill the vacancy. So we have to take all those things into consideration and look at this proposal in the schedule when it is not backed up by the body of the act, and then the practical implications of the things that could happen are there. And I've seen in one of the clauses talking about coalition, because you could have a coalition arrangement, and one of the coalition partners that does not belong to the party of the president or the winning candidate being appointed as vice president, because that might be their coalition arrangement, and then they run into problems. That would put this country into some trouble. So I would suggest that the issue of having a vice president indicator should be out. Finally, that of an independent candidate. See, we ought to realize one thing, that an independent candidate is solo. He or she does not belong to a group. Candidates sponsored by parties, when they die, the parties are given an opportunity to nominate another person, because already this is an organized group, and then it is that group that has put up a candidate. And if their candidate dies, then they must be given an opportunity to nominate another person in substitution to the dead candidate. But for an independent person, if the independent person dies, where do you turn to? You don't turn to anywhere. So that is why you cannot postpone the elections because of the death of an independent person. I think that's the rationale. Mr. Chairman, I thank you very much. We'll do the rest in our write-up. Thank you.
Thank you very much. We have heard from the leader of the United Democratic Party, and let me seize the opportunity to welcome the national chairman of the Gambia Moral Congress in the person of Honorable Mai Ahmad Fati. So I think so far on my list, or on our list here, if he was not in, then we are going to get the reaction of members as per the positions of the respective parties. But now that he is on board, I think it's fair enough we give him time to also give an overview of the position of his party as far as the election is concerned. Honorable, you can get the mic.
Thank you very much, Mr. Chair. I want to thank you very much for the invitation to engage us in this historic process. Let me state ab initio that we shall also present, in fact, at the finishing stage, present a position paper which clearly outlines where we stand on most of the issues here, as outlined in the draft. However, I'll go over just a few that we feel important that needs to come out at this stage. I will refer you to page 13. I think it's a lot easier that way. Page 13 to qualifications, that deals with qualifications for registration as a voter. Chair, we are absolutely concerned by virtue of experience that Section 13 in particular, or Clause 13, qualifications for registration as a voter, and specifically Clause 13, subsection 2A, subsection 2. Now, we believe, also we share the view, of course, by Gambian practice, birth certificates would signify citizenship. That has been the accepted documentation for acquiring national, for ID cards and passports. When you submit a birth certificate, prima facie, you are deemed to be a Gambian, or otherwise, unless if there is a contradictory or overwhelming evidence that suggests acquisition was otherwise. But here in the Gambia, from independence to date, to acquire any national service or employment that requires proof of citizenship, birth certificate is deemed to be evidence of nationality. And I do agree with the extension that was accorded it by the honorable leader of the United Democratic Party, that obtains in many countries, and that is the case. And I'd like to see that here also, so that we can eliminate the issue of statelessness in the Gambia. And this is something we're very passionate about. So whether you're a Gambian or a non-Gambian, there should be evidence that when you are born in the Gambia, you have a document to prove that you were born in the Gambia. So every person born in the Gambia, or found himself or herself being born in the Gambia, would have a document that would trace to your place of birth. Nonetheless, we believe that along the analogy of attestation, which is clearly stated in 13(2)D, we believe they serve the same purpose. Because we must look at the objective reality of the Gambia today. It is absolutely easy to obtain a birth certificate within a very short period of time. That is the reality. You want a birth certificate, you can obtain one in less than a few hours. You can obtain a birth certificate. Now, for election purposes, birth certificate is just a piece of paper. There is no picture identification attached to it. So anybody whose name is Fabrama Sane or Ibrahim Mane, because the Nyanchos are the ones I can hang on to, any of them, Fabrama Mane can come and say, I am actually, Ibrahim Sane. And there is no evidence, empirical or otherwise, that would displace that. And he would be allowed to vote with a mere document. Just like an attestation, which is signed by a SEFO or an alcalo. With a simple document, you can go in. So I am saying, or our position is, we do away with birth certificate because they are subject to fraud, easy to access and easy to abuse. Now, with regards to, that is 13(2)A, with regards to 13(2)D, our position is that while we agree that SEFO should have no place in this, absolutely, we believe an alcalo, in addition to a compound head, in fact, the initiative should come from the compound head, then to the alcalo. So if you are from village A, let's say you are from Dankunku, the compound head, with the compound where you originate from, the compound head of in Dankunku would affirm that you are indeed somebody from that household. Then it goes to the village alcalo, who would certify that, and then that can go. That would prove conclusively that you should be from that, or except otherwise, another superior evidence that suggests fraud took place. But of course, you cannot have a full proof, so there is some point where we must stop. So we would say an alcalo in addition to a compound head. Somehow that can be redrafted. I'm not just going straight into how the drafting should read, but there should be a place there. And SEFO should be absolutely deleted. SAFO should be, it is for additional safety measures, because we know, I agree with the previous speaker, the SAFO does not know the name of my son and cannot even prove that if I have a son or not, for example. So if you want to go to Kerawan and the SAFO doesn't know all the residents of Kerawan, obviously it makes no sense for a SAFO to confirm something that he cannot swear to his personal knowledge or experience or otherwise. So SAFO should be removed. It is unsafe and it is subject to abuse. It is a floodgate for fraud. So it should be eliminated. We would go to refer to page 15. Specifically to section 18 or clause 18. There I would like us to define what a voter is. I think we believe that it should belong. First, we talk about transfer of voters list. We're talking about voting here. Who is a voter? We believe there should be, the interpretation section should be clearly defined, and what a voter's card is, so that we eliminate some of these things. Eliminate the idea of attestation and a faceless birth certificate that is also easily obtainable. I mean, we know this, there's a lot of experience for this. Many of us would be honest that it's quite easy to obtain a birth certificate too, unless we have birth certificates that are accompanied by faces, by face ID. And this was something we are working on. Well, that's not the venue for that. All right, so essentially we believe that should be, there should be, a voter's card should be defined, so we know what a voter's card is clearly. And it's go to that section, the section that deals with it, with that. We would ask you to refer you to page 19 as well. Page 19 deals with revising court. Well, it's quite clear. The spirit is that the general spirit is expedition. How do you get processes really expedited in such a manner that delay would not result to any harm to any individual, any person there. So I am minded, in fact, in order to give that importance, because there's a couple of sections, series of sections on the revising court, and I'm sure the constitution is also clear on where these things should go to. But in the interest of saving time, I would just propose that it goes straight to the High Court. You know, that is our proposal.
Can you mention the clause that you are using?
Clause 28 deals with the revising court, page 19. I know if you look at the jurisdiction and the matters that come before a revising court, it relates more to summary issues, you know, things that can be dispensed with quickly and, you know, with expeditiously. Is the chair, the co-chair with me? Yeah. Yes. So precisely that's what we talk about. All other issues that are connected to the revising court. You know, we're saying that because there it talks about appeals to the High Court from there, and election periods are quite limited. Periods are quite limited, and oftentimes before these decisions are made, although they appear summary, you know, primarily on the surface, they appear that they are matters that you can deal with easily. For greater expedition, in order to have the process more expedited, we are proposing it might perhaps create additional cumbersome or some burdens on the judiciary, but make it the business of the High Court instead. Here we talk on Magistrates Court, and from there you go to the High Court on appeals. You know, and before it is totally disposed of, the election period is over, so it becomes a moot point. You know, in some cases, yes. You could operate backwards to say, well, if you are not supposed to vote and you voted either way, but how is it there to prove, you know, who you voted for, who you may not vote for? We go to page 40. Page 40, that is clause 62, directions on voting. Here I am a bit troubled by 62A, you may vote. This is the returning officers, rather, shall call notice to be printed in a conspicuous character and posted in various places, in the following terms as the commission may direct. So like it says, you may vote for one candidate only. There is discretionary. You may vote for one, but you may also vote for two. So I think we should be very clear on that. It should be very specific. You can only vote for one candidate. So the word may should be amended, not to allow for discretion. Because you can vote for A, then you can vote for B, and then you will use section 62A as your strength. And then page 41 as well, 65. For me, there is some disharmony here. 65.1 and 65.3. 65.1, polls at polling stations shall commence at 8 a.m. and close at 5 p.m. 5 p.m. It's very specific, between 8 and 5. And it uses the word shall commence at 8 a.m. and close at 5 p.m. So it means at 5 p.m. the polls shall actually close, not beyond. But 65.3, say at 5 p.m. the presiding officer shall assign a security officer on election duty to ensure that no other person joins the queue to vote at 5 p.m. So it means election can proceed beyond 5 p.m. It only says you cannot join the queue after 5 p.m. So that needs to be harmonized so that a provision is made, a proviso that you can, and provided A, B, C, D, then it can be more neat, so that we are not caught up by the 5 o'clock. I mean, this harmony, this apparent inconsistency needs to be reconciled. Then you go down to 66.4. 66.4 as well, where a voter, because to us, we find this to be an infraction, and it should attract consequences. Where a voter is not the same person whose name is on the register of voters, or B, has already voted at the election, that is fraud. Clearly, if your name is not there, that may be an omission on the part of the commission. That could be understandable. There may be your name should have been there, it's not there. That could be an omission, it could be innocent, could be intentional. But B has already voted. You knew you had voted and you don't have a right to come back again. Obviously, your intention is mala fide. So we are saying that important element of fraud on the part of the person should go to section 69. Section 69 deals with offenses within the polling station voting. There, it should not just be, because it says if you do not, the presiding officer shall not give him or her a ballot token. That is like, a pat on the back. Oh, you voted. You've already voted. You don't need to vote again. It is rewarding bad conduct with nothing. And you're talking about elections here. So that part should go to the offense section. And not simply not be given a token. You should not be given a token and there should be further action against you. That has some criminal import, there's a lot of notations made here, but time is going, and I know Kek Sane and his clan must be hungry by now. So we would definitely submit the rest as an opinion and allow others a bite at the apple. Thank you.
Thank you so very much. Honorable members, I want to talk with you because you will agree with me that the day has been very long. And you can see the amount of commitment and interest that the respective leaders who have appeared before us have demonstrated. I don't know whether you have concerns that you want to raise, but I will, to an extent, try to exercise certain powers because definitely we cannot keep them that long. So I'll use my discretion and I will decide when to stop because the interaction will be ongoing. So the first hand I saw was from the Honorable Member for Lower Salem. Yeah, of course. Wow, no, dapat distract. Dinañ am information internal bu ñu share. No, you look at what you have, prioritize it, and ask one question. Because I heard you say my first question or my first intervention. You have only one chance to ask one question.
Only one?
Yes.
Allow me to read it out, then I'll
Okay, all right, thank you. Let's move to the other member for the governor. The governor was second.
I thought I was the first. No.
Thank you very much. Honorable Koke, I think this question will go to Honorable Ahmed Fati and Honorable Wilson Dago. There are different positions regarding the question I am asking. I pick from Honorable Maifati that on the issue of attestation, the alcalde could be maintained and that of the keys be deleted for the alcalde to be supported by the head of compound or something like that. I want to recall that in the Election Act that was amended 2018, Section 13D, there was provision for 5 elders. Are you trying to say that in the position of the 5 elders, we have the head of compounds to support the alcalde? In the same vein to Honorable Dabo, I heard you also say that yes, the alcalde could be very useful in issuing attestations, but the chiefs may not accurately attest because they may not be in position to know everybody within a particular district. But I did not hear you mention anything about the 5 elders.
Thank you. So can we start from Honorable Dawood, and from there we move to Honorable Fati.
Yes, I have not mentioned about the 5 elders because those 5 elders are in the shadow. They are not in the act. So for me, it was just taking from the Elections Act, current Elections Act, and embedding it in this draft. And certainly, since it is not catered for in section, in clause, clause 13, yeah? Since it's not catered for, I don't think the issue of 5 elders should really arise because you will be having 5 elders doing attestation, also have an alcalde doing attestations. And their attestation could conflict. And as far as the Safehold are concerned, I did say that the Safehold, for the village in which he lives, maybe he could attest to the claim of a person from that village, but not outside of his village. Yeah.
Honorable Fati, the press will want to have you. Maybe you wait for their gadgets.
Yeah. Thank you, Honorable. Thanks, man.
Thank you very much, Honorable National Assembly Member Alhaji Dabo, for that intervention. We hadn't advert our mind to the 5 elders for reasons of lack of specificity, because they are not identifiable. There could be 5 elders, one from Sanukunda, another one from Manekunda, and then you have the rest together. And there's no attachment. So here, section or clause 13D as drafted, should trace to a root, because what it talks about certifying that he or she is a Gambian, you know. So and that's not enough. It should continue by virtue of birth or, you know, Gambian by definition should be there, so that the 5 elders may not necessarily be the best way to identify who that person is, because they may be in the same shoes as as the SAFO. And equally, there are instances we all know all over the country. There is migration, domestic internal migration. People move from one village and settle in another village. And they may live there 30 years, but they're actually 50 years old. So when they got to that village, they're already 20 years, or they're 2 years or 5 years. And they're deemed to be citizens of that village. But there, even the alcalde may not be able to confirm whether their origin of their origin of birth, wherever they came from, they migrated from, whether they were actually Gambians or the parents were Gambians or one of the parents was Gambian. So it can be dicey sometimes. You know, in my village, we have households that really migrated elsewhere and came to settle in my village. And when some of them were coming, they were young. In fact, there's a few of them who are my age mates. We play together in the bantabas and so forth. But they came when they were much younger. They were actually not born in the village. So there, how do you reconcile? How do you define? How would the alcalde be able to say, really, these are Gambians? Because to be a Gambian, there's a legal definition of what a Gambian is. You know. But like I said, we can have full proof. Suffice it that a compound head, the person in whose household you allege to be, together with the alcalde, should be sufficient to identify you as a citizen or as a resident of that village of Gambian nationality. So the 5 elders we talk about really is another bad route to travel, because those 5 elders are not defined. They could be one from Kombo, one from Kiang, another from Badibu, 5 elders combined to say you are from a Gambian, from a locality they had no idea about, whose geography they have no information. Thank you.
All right, let me take the honorable member for Salah Sanjal.
Thank you, Co-Chair. Since you allow us to take only one question, I would prefer to direct my question to the representative of the PDOIS. Honorable Sar, you did mention in clause 49 of the Act, you propose an additional provision where you indicated that when an objection is made, a fee should be charged to such an individual if he cannot substantiate that. And I just want to ask, you said IEC should not be left to direct that charges. In your view, how much do you propose to be the charge? Because we want to get your position on that. How much do you think would be required for such an individual to pay?
Yes, in the past, it used to be, it's not that that is being proposed that there should be a fee, it's already there. The proposal was that the fee should be reasonable. In fact, there is a counter proposal that IEC should not fix the fee, but that should be left to the National Assembly. So, what I remember before, in the First Republic, the fee for an objection used to be $2.50 bottles. Well, that may seem to be low, but if you think of that, at least $5 for every person to which there is objection. So if you have 100 people, that will be about $500. Thank you.
It was revised to $100.
Pardon?
It was revised to $100.
In the First Republic?
Yes, it was revised to $100. No, not in the First Republic.
No, I'm saying in the First Republic. Yes, First Republic.
Okay, let's take another question from the honorable member for Brikama South.
Thank you very much, Honorable Co-Chair. My question is connected to section 13 of this 13 of the election bill. And I did remember during our first engagement of consultation, we've invited the IEC to make their position, which of these instruments are they going to use to register. And they made it abundantly clear that they are going to use the existing act. So if you come to the same bill, you have section 13, which is talking about the registration, qualification for registration, where the issue of birth certificate and the issue of this attestation is not very much clear, as alluded to by Honorable Ahmed Fati and Honorable Dabo with regards to the birth certificate, where they have some observation of the birth certificate and the attestation. But if you go to the existing act, you have the birth certificate is there, which they are going to use to register. And also we have the attestation by the 5 elders. And they've already made an announcement that on the 29th of this month, they are going to start the registration. So what is going to be the position of the political parties? In the same vein, if you look at section 107 of the bill, that is talking about registration of political parties. We are made to understand that the country go in for election at every 5 years. So political parties, like you look at 1G of 107, that is talking about the biennial Congress of political parties. We all know how difficult it is to conduct a political, to conduct a congress, political congress. If you look at the burden is too much on political parties, if it can be done at least once before every presidential election. What is your take?
Sorry, the question is directed to an individual.
Yeah, that's for everybody.
Whosoever may choose to answer among the political parties.
Clarification.
Clarification,
Yeah.
Sorry, is it on the issue?
On the issue.
Okay.
Yeah, I think the act that the honorable member is referring to, that IEC did say they are going to currently use, had been amended 2015, and then the provision for the 5 elders had been deleted. So unfortunately, we have the text that is not the latest version. That's why we still have that 5 elders in that version, but it has been amended. It's no longer there.
But we still have the birth certificate there.
No, that's there. I mean the 5 elders.
Thank you for that clarification. Yes. Can we have reactions of the political parties as per the comments made by the honorable member for Brikama South?
Well, really, we do not have any strong position on this, but I want to say that in 1996, when we established the United Democratic Party, this is a provision we have in our constitution. We had provided for this even before the National Assembly of the Gambia thinks that it should be in the constitution of the parties. But again, at least you may not hold elective congresses, but certainly I think it will be proper to hold congresses at which the party members would be informed about the affairs of their party, how their party has been managed, particularly their finances. I think it will be proper. Maybe for elective offices, maybe we can have every 5 years.
All right. Honorable Fati's hand was up. From there, we'll go to
Thank you. I thank the member for Brikama South for that intervention. We believe that political parties as an institution, a government in waiting, should mimic how a government operates and functions. And as far as practicable, political parties should behave like a government. And government is all about accountability. You must be accountable to the citizenry. And this accountability takes place almost on an annual basis. You know, when the president goes before the National Assembly and makes State of the Nation address, the minister comes before the National Assembly and ministers are questioned. And this is an ongoing process that happens all the time. In order to actually strengthen democracy in general, national Gambian democracy, the foundation had to be internal democracy within political parties. That political parties must themselves subject themselves to the rules that they would like to see citizens subject themselves to. Now, as a result of that, and in consequence, well, which is about saying, we believe that the situation as it is now, minimum every 2 years, political parties should go on a Congress. You know, and this Congress should take stock of what happened, and the members, that is the way that the general membership would have, you know, a direct input into the performance of the party, and also audit the party's officials as to their competence, you know, as to whether they should stay or not. Now it's subject to the individual political party constitution as to whether they can go for congresses that are not elective or that are extraordinary. There is no specific definition as to what an extraordinary Congress would be. It is what the political party constitution says what it is. So, but our position is that we would, as much as possible, allow these 2 years, every 2 years to stay. We've also had it in our foundation constitution. When GMC was created as a political party, the constitution that was submitted to the IEC for registration contained, you know, the right of the members to question its leaders at the Congress. You know, and we want this, we would like to see this further strengthened and not extended to every 5 years, once every 5 years. Thank you.
Well, PDIS has a constitution which was written in 1996, which we still retain. And according to the constitution, we have 2 congresses within 4 years. One Congress is elective, that is the one which we have every 4 years, and the other one, after 2 years, we do have a Congress. So we don't have a problem with that. We do this because it is very clear, in accordance with the Section 60 of the Constitution, that the internal operation of a political party must be democratic, and therefore its leadership should be held accountable at a Congress. And we feel that 2 years is quite a reasonable time to do that. Thank you.
Thank you very much, Honorable Co-Chair. Honorable, our party is in support of having Congress every 2 years. We believe that internal democracy should start within our political parties. And going for a Congress every 2 years would avail the opportunity of the membership to vie, of course, for positions, and as well make key decisions, because most political parties, as in their constitutions, Congress is the highest decision-making body. It will also avail them the opportunity to discuss pertinent issues as they affect their party and the country.
Therefore, we are in support. We have no problem with this provision. And maybe even some could suggest that you could, because having a body that is empowered with making the highest decision making for a political party, and for them to meet, unless extraordinary Congress is every 2 years. In fact, it's a long duration. It even could be every year, maybe most likely. That's my opinion, Honorable. You wait for your turn. That could be probably give them the opportunity to partake in the policies and programs of the party, and also for them to be abreast with whatever happening, especially the finances of the party. Then the second year, you could go in for elective position, so that they will take part in the internal democracy of the party. Because we want to be, all political parties aspire to lead the country. And when you are to lead, you must have some tenets of basic democratic principle, and elections or choosing leadership of political parties is key.
Thank you very much, Co-Chair. We also at the Gambia Party for Democracy and Progress firmly believe that it is necessary for every political party to conduct a biannual Congress, which is elective, of course. And as CD have suggested, if it's possible, because logistically and financially, if it is possible, it would have been even necessary for us to have it annually. But some parties are not, all parties are not the same, and as such also that also has to be considered as a factor. But as much as democracy is an important aspect of every political institution, it is also necessary also to give a fair chance of many political parties, especially those parties that are coming in that do not have the resources of many of the parties that are already established. As such, I would suggest that the 2 years be maintained, and as such be elective as well. So so that at least there will be democracy, and also consideration for political parties that are not as powerful as parties who are already established in this country. Thank you very much.
Thank you so much. We've got so many reactions from the parties that are with us here. So let me take the next question from the honorable member for Uganda East. Honorable members, I've seen your hands rather. So
yes.
I
Thank
have you on my list. That is how I will call you, please.
Yes. Thank you very much. Well, I have some members giving the emphasis of presidential candidates, be it independent presidential candidate or a political candidate. And the emphasis was whether do we need to suspend or postpone an election when a party candidate died or when an independent candidate died. Here we are talking of two entities. One, a political party, as we all know, this is an entity that is well structured with a flag bearer, party leader, deputy party leader, and the list goes on. Independent candidate, perhaps one might say these are entities that are suddenly formed, and maybe they might have just a party leader and maybe followed by the supporters. Here, don't you think there might not necessarily be a structure? This is something that we are observing. Maybe it is happening in certain geographical areas within the country. And what are you suggesting in the event that maybe an independent
candidate dies, what period are you suggesting for us to give that entity that time frame in order for them to come up with another flag bearer or leader? Because for a political party, that the deputy party leader can easily come up to represent the leadership of that party. But in the event of an independent candidate, what time frame are we suggesting here to allow that entity to be able to come up with another candidate? In as much as you are giving the emphasis that there is need for the election to be suspended or postponed when either of them die. Thank you.
Yeah, thank you very much, Honorable. I think as per the bill, you know, political parties are organizations. They are organized, an organized group. And then they have structures, they have executives, and then they mobilize, coordinate as per the guiding principle of their constitution, and of course the electoral laws. So therefore it's an organized organization. It's different from an independent candidate. You know, independent candidate, I had you say maybe party leader. Independent candidates, because of they don't have political parties, they are called independent candidates. It's an individual who come up with the decision to contest whether presidential, parliamentary, mayoral, or other elective on the local government. So therefore, because of that, it's not an institution. So that is why it is only prudent when somebody died as a candidate, of course, from a political party, because they're structured and they have spent a lot of money in organizing themselves. So it is only prudent to give them time for them to bring in a substitute. But as an independent candidate, when he dies, where to fault, Honorable? You referring for them to come with a political party. Who is an individual? Are you going to his son or a daughter or a wife? That is the reason why there is no need to postpone the election, because it's an individual. Even though maybe his family could mourn, and even the country could mourn, but it's an individual. That is the reason why even the other speakers who contributed indicated they have no problem with that.
All right, let's
Thank you, Honorable, for that question. I suggested earlier on that even for an independent candidate should warrant the postponement of the election. I think we shouldn't take it like where to resort back to, but what impact the death would have in influencing the outcome of the elections. And that was the issue why I was saying even for independent candidates should be considered. We have seen in the past where a great number of the population rallied behind an independent candidate. In that instant, if such a situation should have existed, and then we resort or let things go, the outcome might not or might influence what would have been the choice and or the will of the people. So it's not only about the political party is organized and therefore can easily come up with another person, but that postponement would also allow people themselves, to, if possible, they may have other choices or other people that may see the need to come out and contest again. It is even possible that the independent candidate might have been working with other people that also can come up, and then contest. So issue here should be about what influence would the death have on the outcome of that proposed elections, and not only about where to resort to. Like we have seen just in 2016, a vast majority of the population rallied behind the independent candidate. If something would have happened, and then we just let go and move on, it is possible that the outcome of the election would not actually represent what would have been the will of the people. Thank you.
Yes, you can.
No, by the representative of GDC is quite different from the other one. The 2016 coalition is an independent candidate backed with political parties. It's not a solo in that case. So it's different. We cannot compare the two. Thank you. It's not the same.
Okay, who else wants to react?
I think my question is not understood.
Your question is not understood.
Yes.
Can you
I
repeat it
have
again?
others emphasizing the need to suspend election when both a party candidate or independent candidate dies. I heard of this man talk about it, and of course, Mr. Samsar did talk about it, that there should be that equality, and the law should not discriminate. They talk about it. Now, I am asking those individuals, if we are to go by that, what is the time frame that should be stipulated in order to allow them to provide another candidate? That's my question.
I think you are posing a difficult question to.
No, it's a suggestion.
Yeah, that's okay. Anyway, Honorable Dabo wants to respond, but.
Well, Honorable Member for Nyamina is, yes, we certainly want to be non-discriminatory. But the question is, if you postpone the elections, whom are you going to ask to step into the shoes of that independent candidate? Because you have to have a fallback situation. Whom are you going to ask? After this, as independent candidate, he may have his following. But that following does not really give him a successor. But for the party, when the party's nominee dies, the party that is organized, can really put up a candidate, because you have a fallback situation. And for the impact, after all, Mr. Tal, an independent candidate, if no, I wouldn't say it. No, I'll say another. For instance, at the time that Mr. Diba died, at the time that Honorable Lami Diba died, if he was an independent candidate, the impact, how would that impact? Because Mr. Diba's popularity, would that translate, or would that be transferred to me if I'm contesting as an independent candidate? So it cannot. The impact cannot be there. So when an independent candidate, these things happen, it's unfortunate. The elections will just have to go on. I think we want to be innovative. We want to be really accommodating, but we should do it with some reasonability, some objectivity. Yeah.
Okay. Thank you very much. I think the scenario given by my friend on my left is very, very important. I think people don't understand what he's trying to say, draw attention to. He gave 2016 as example. If you have this provision, if we had this provision in the elections bill in 2016, and the scenario he was trying to give happened, the authorities would have rushed to declare the lone candidate winner. This is what he's trying to point at. Yeah, because we had a coalition behind the candidate. If they are given chance, they could easily come up with a replacement candidate. So let's look at it in these two ways. Thank you.
Well, you want to...
I just want to clarify on this point so we can move on. I think with the example he is giving, what he's actually trying to make us do is to create a provision in case in that situation. I think that can be easily done. We can go ahead and create another provision that would address the situation of 2016, the issue of coalitions. And I think that is kind of missing in the Act, has not dealt very well with the issue of coalitions. Honorable Chair, with your permission, I'll move on to my question. You've given them, the gentlemen, too many chances.
Just allow me. You requested for the floor to clarify.
Okay.
By virtue of the fact that you are the only female so far whose hand is up, you qualify to continue.
Okay. Thank you very much. My question is, and it goes to...
I'll come next. Next, I'll come direct to you, please.
Thank you. It goes to the legal minds on the issue of the birth certificate. I'm sitting here thinking the birth certificates issued here in the Gambia, I don't know how we missed this all these years, because it doesn't even state nationality. So it means in the first place, it cannot even be a document that can be used to identify whether someone is Gambian or not. Because I don't think there is anywhere in the birth certificate that states, like the passport, you have your nationality Gambian. The ID card, you have your nationality Gambian. That's why we can use these documents to register. But the birth certificate doesn't state this. So I'm just saying to the lawyers...
Can I observe you?
Yes.
Maybe it has to do with the issuing authority at the time. But Gambian birth certificates, normally, if you look at the back, you are able to establish who is a Gambian and who is a non-Gambian.
It states your nationality.
Non-Gambian parent. Something like NGP, I'm not too sure, but it's a three-letter word. So you can establish who is actually a Gambian through the look
No, but even with that, the NGP, the non-Gambian parent, it still doesn't go to the definition of the Constitution, because it doesn't identify whether one of your Gambian is parent or both two. It's not very clear. The mother could be a non-Gambian, but the dad could be a Gambian. So,
in that context, your birth certificate is not authentic. I'm saying in the event you are issued a birth certificate because you are born in the Gambia, just as we agree, being born in the Gambia doesn't make you a Gambian. There are conditions that you must...
I understand, and that's where I'm coming to.
It is written there, and it means you do not meet any of the qualifications. What the form should be. I guess you understand.
Yes, so my focus is what is contained in the form, whether the form actually states your nationality, because you can only be registered to vote when you are actually a Gambian, whether this is in the form or not, and also the identification issue. I could carry the birth certificate of my elder sister, if I wasn't known, and go and register. Who would say, I am not that person? There is nothing in the birth certificate that could. So I'm just saying, with the lawyers, would not this give rise to so many issues in the revising court? Because it means anyone that registers with a birth certificate, I can challenge their Gambianness in the court, and this would create a lot of problems. So I'm just asking this to the lawyers: should we just let go of it, or we can still keep it and face the risk?
Well, I had wanted to say, yes, we can seek the opinion of the lawyers, but it's a very valid point that has been raised. And this is one of the reasons why we were to be accompanied in the process by IEC and the Ministry of Justice. Unfortunately, both are not with us today, but as a joint committee, they are very sensitive and will take note of it. Notwithstanding, we can hear the opinion of other lawyers and whosoever it may be in the room here. We can hear their opinion, but notwithstanding, we will make sure we take note of it and we engage both IEC and the Ministry of Justice accordingly. Because I am seeing a lot of sense coming out of the discussion. You want to clarify? I know you want to clarify and capitalize and hijack. Go ahead and ask your question. You are not only clarifying, but you want to ask your question. Go ahead and ask.
Thank you very much.
Thank you very much.
Thank you very much for giving. Thank you very much for giving the floor. I will clarify and also use the opportunity to ask my question as well. You're not the chair. Under the birth certificates, I'm a living witness to that. You know, of recent, there's an immigration post in Kantora, Fatudo. The CFOs, in fact, the CFO and the Alcalo, they work in collaboration. It's only one paper and on the attestation. You have the left side of the paper bottom, the stamp of the Alcalo. And the right side of the paper, you have the stamp of the SAFO. So issue of attesting doesn't really emanate from the SAFO. It emanates from the, it emanates from the alcalos. However, if you look at the birth certificates, there's what you call NGP, non-Gambian parents, beneath. If you go there, a lady was stopped not to be issued an ID card. She come to me and then complain. I said, but of course, the SAFO has already written that you are not, your parents are not Gambian. According to the Constitution, that has really gave a reflective interpretation of what the Constitution is saying. Then one of your parents must be a Gambian. And in the birth certificate, that was the control mechanism that was inculcated there. So you having access to birth certificate doesn't really give the impression that you can have an ID card or election. There are control mechanisms. You can go out and you will see those things there. Thank you very much. Having said that, my issue is about the notwithstanding subsection 1. I'll refer you to clause 54. Notwithstanding subsection 51, the death of an independent candidate shall not be a ground for postponement. I want us to have a different lens. I don't want us to be treating equals on equal. Every candidate or every Gambian citizen has a right to vote and be voted for. Haven't given them that constitutional right that they can contest, they can vote and be voted for. All of them, stood as a candidate and then contested. Unfortunately, as an independent candidate dies. These are two equals. My issue is not to treat equals on equal. Now, suddenly he happened to pass away. That the way and manner the party member or party candidate is treated, the IEC could easily go and lean on the nomination form. He didn't come there alone to say he is solo in the game. He has people that backed him to bring those requirements, nominate him. Nothing stop IEC from going to those nomination lists, get the people responsible for his nomination and contact them to prepare themselves for the election and postpone it. So I am of the conviction that it really warrants a postponement. Either you are a political party member or you are an independent candidate. Because I want to see that all equals are treated equally, not treating equal on equal. Thank you.
Well, I just want to say this. We don't need any reaction because what is happening is we are here to take information from you and not to show you our position. So as a result, Honorable Sir, no need to react. Just tell us your position by sending us your position paper and then it will be captured as part of our report. Yeah? So can we have the Honorable Yasin?
Thank you very much, Chair. My question is on the diaspora. You know, we are saying that, as the Honorable Oku said, that it is already on the, is it on the Constitution or on the bill, that it should be the 8th constituency. So in case that it is not on the constituency is not there, don't you think that there should be access to be able to register and then vote? Because if you look at what is happening, the diasporans, they are very, very important. And they were with the hope that they will vote. And then if that does not happen, how would the elections be? Because really we need to think about it and say something about it, because the diasporans, they are very, very important.
Thank you.
Is there a question or the question?
Yeah.
It's just asking for the date did not happen.
Honorable Sector, what I did says that government has declared the Gambia, the diaspora, as the 8th region. And because of that, they should be treated as we treat the 7 regions in the Gambia here, and that they should be allowed to vote. You're making provision for qualification to register, and one of them is to be resident in a foreign country. So really, the law is there. So what remains is really the implementation of the law. And I do not think there should be any justification to deny them the franchise to vote. That's the position on the whole. But at the end of the day, Madam Seka, I say the matter will rest with you, members of the National Assembly. You are the ones who are going to make the laws, and then having made the laws, you will see also to read that the laws are implemented. If there are resource constraints, you will find the resources to make sure that the provisions are implemented. At the end of this, it will be for you.
All right, honorable member for Lower Salmon.
Because you are not following this, why? You are not following.
Remember, he was the first person to ask a question, but because he had wanted to ask more than one question, I told him to prioritize. Look at this set of questions and choose one. So he allowed members to ask, then I can call back on him, and that's what I am doing. I told you, you signaled me, and I said I saw your hand. I'll call you. Just be patient with me. I'll call you.
Thank you for overruling him. Thank you, Honorable Chair. My question goes to the Honorable Usain Ndabo, the Secretary General, UDP. I don't know whether I digest you right. You mean the law has already provided the 8th region of, and diaspora is the 8th region. Here is a draft law which is not yet implemented. Now it's just a draft. My question here is Section 39(1), as you know it, and you know it more than me. It's an entry clause. You get Section 88 of the Constitution, the 1997 Constitution. Already, National Assembly is restricted to 43 seats with 5 nominated members. No, 48 elected members. No, allow me to come, please. It's 48 elected members and 5 nominated members. That goes to 53. It's 53. Yes, 53. I'll take the feeling. I'll take the feeling. 58. 58. No, but no. All of you can only rectify me once. Somebody will speak.
That's why I am saying.
Only one will speak.
We allow him to ask his questions. And if there is anything that we object or we want to observe, I'll give you the floor, you observe him and correct him.
I think it's right like that. Thank you, Honorable Chair. Now 53. This 53 now. This diaspora as the 8th region. Then as 8 regions, diaspora. Then they will automatically get a seat of National Assembly. While before going there, there is a clause. That is an intake clause. That's 39(1). How can we go about that? Thank you.
Now, maybe we should get one thing clear. What I said is that the government has declared the diaspora, not that there is a law making the diaspora as the 8th region. And I said I was rationalizing that because government has so declared, for purpose of demarcation, you can treat the diaspora as a constituency. Yeah? Now, this, what you have here, there, is elections to the National Assembly. Currently, what is, in fact, the elections bill, in fact, the current, because I understand this might not be passed for the next presidential elections for registration, so that you have the Elections Act, which makes provision for IEC to make rules and regulations for the registration of Gambians in the diaspora for presidential elections. And I think it has been more practicable, even by our neighbors here, that the elections that they partake in is always presidential. I'm not sure whether it's extended to National Assembly. And we can also start with the presidential election and then progressively go on until we attain a situation where you can even vote for local government representatives. Because the issue for that, I think, for me, it could have some logistical problems. You have somebody in New York from Kauru Ward. You have another one in Minneapolis, also from Kauru Ward. If they have to vote in local government elections, how are we going to register them? But then, for purposes of presidential elections, every constituency, would be declared as an electoral division. So you can register the voters in the diaspora to vote in the presidential elections, and then progressively we go on to see how they could vote at National Assembly elections, not only vote at National Assembly elections, but also to be represented in the National Assembly. I think those should be in our thinking.
Thank you very much, Honorable. I think last on my list is Honorable Bundu Kakunda.
Thank you very much, Honorable Chair. I want to ask Your Excellency, Lawyer Usainu Dabo, you did mention in your deliberation that it was happening before, that an interview panel is set to ascertain the attestations of the alkali. And I was sitting down here thinking that can be a great instrument to defraud our register. But I want to know, how was that panel constituted to interview those coming with the attestation, so that they can be vetted again to make sure that they are Gambian? And also, the representative of GDC, I think, made mention of they all have a position on all these issues we are talking about now, that is the inter-party. Is it possible for that to be available to us as a committee? Thank you very much.
Well, I will let Honorable Dabo answer the first question. And concerning the IPC, in our work plan, you will realize that they are already catered for. They will appear. Yeah, so needless for him to respond to that question. Yes.
Honorable, thank you for the question. There was no panel. It was the registrant officer who conducts the interview, because you make a claim to him and he interviews you and then gets satisfied that you are qualified to be registered, and then he would register you. And then if he rejects, if he's not satisfied, he rejects your claim, and then it will be for you, who has been rejected, to appeal against that rejection to the revising court. So there was certainly no panel established to do the investigations, and we are just proposing that this should now come on. And one of the fundamental flaws I see with this is documents to show that you are entitled to be registered. Now, let's be quite clear. The Honorable Co-Chair, he has been minister in this country. He's a member of the National Assembly. The Honorable Speaker, he is Speaker of the National Assembly. You know, do they go to the registration center with the presumption that their citizenship is in doubt? I think it is when your citizenship is in doubt that there will be a demand for you to prove it, and then you prove it by production of an identity card, production of a passport, or one of the other documents. But you do not, as it is, there is a presumption that I'm not a Gambian, so I'm going there to prove that I'm a Gambian. And I think the presumption is to proceed on the presumption that the person is a Gambian. As I said, Honorable Chairman, you proceed on the presumption that he's a Gambian. If anybody contests that he's not entitled to be registered, then he proves that. I have my birth, I have this. And I think for him, the easiest way to do is that I have been minister and a member of the National Assembly, and I couldn't have it without being a Gambian.
Thank you very much, Your Excellency. I think now I'll allow the co-chair, who also have a few issues that he wants to share, and then that will do. We call it a day.
Thank you.
They are not taking your rights. They are not seizing your rights.
Okay, thank you. I think I'm leaving. Yes, for me, I have only very short questions. One is that from experience, you go to big settlements like Brikama, Serakunda, Farafenye, etc., and people will register, and agents will continue to follow, try to find out where those people live, but they will not have even the opportunity to serve them for revising courts. So what is your take on ensuring that this bill entails a clause which will say that in big settlements like that, we should have street names and compound numbers? Because that is very important. If somebody registers and you want to know whether the person is actually properly a Gambian or not, or residential or not, you need to be able to know where that person lives. But then with big cities like Serakunda, how do you follow somebody? What is your take on that? That is my first question. Bring them all. Okay. I also raised the other question. Mr. Dabo also.
The last one now.
Mr. Dabo also raised a question that I was raising throughout. That is the issue of coalition formation. It is stated here that parties can form coalitions, but the issue is after you form coalition, and then the candidate of that coalition becomes a winner. And then at the end of the day, he reneges on all the agreements, which can create a lot of crisis in a country. We all know the country could have gone into crisis. And we know what happened in other countries where issues like that happen. So don't we need to have a clause to state exactly how the modalities of that coalition should take place, and what will be the guarantees for parties that are coming into that coalition? Those are my two questions. Okay. Thank you.
Any actions? All right. Honorable Dawud and Honorable Party.
Well, the first one is really a big issue. And certainly, I'm not sure whether it is the elections bill that has to take care of that, or it's not the municipalities that should really address that situation. I would think that the Brikama Area Council should really look into that in accordance with the Local Government Act and not really the elections bill. Otherwise, if you want to do all this, you are going to overburden this. You are going to overburden this act. I mean, issues that are not really quite germane to elections and proper conduct of elections, you'll find them built in here. The issue of tracing the the registered voter, maybe with ID cards and passports might be some problem, but with attestations, the person who attests that he is Gambian, he is born in this place, should be the person to identify where the need arises, his residence, so that if you want to serve him with any documents, he could be so served. And I think the other is that since the Chief Justice has been given the power to make rules in respect to revising courts, maybe issues of service and so forth, he could address it when making the rules. But certainly it's a practical problem, and again, these matters that we think we can progressively attain. It cannot be, certainly not before these presidential elections, and I don't think not even before the next National Assembly elections. But these are things that we should have in mind and then work towards achieving them. Now, the issue of coalitions, should this law make provision how Party A and Party B, how they maintain their relationships? I mean, these are political questions. And I do not think really you can find a legal prescription to really say this is what you must do, this is what you must do. Renege on promises, not renege on promises, among other things. No, that should be left to the political parties themselves to iron out. Because if you want to do this and then you want to go to court, I mean, political questions, I'm not sure whether the courts will really want to be interfering with that. Yeah? So that's my view. Well, yeah, I agree stability.
In other countries where there are coalitions like Italy, if there is a reneging of agreements, the coalition fails. That's what happened in those countries.
Yeah, the coalition fails, and you go to elections.
Yes.
Yeah, but then, how many by-elections do you want us to have? Presidential by-elections in this country. Our resources cannot sustain it. Yeah?
I think that will be the last comment. Did I see your hand up? Okay, all right.
Thank you very much, Honorable Co-Chair. Thank you very much. I'd like to attempt two of your concerns or interventions that are raised. The first one had to do with in big cities, how do you trace for purpose of revising court? There is no provision in the draft that actually deals with it. But in practice, yes, because revising courts is essentially magistrates' court. And as such, magistrates' courts are like all other, like even the superior courts are governed by rules. In the event that you are not able to trace, because now you're not talking about voting issue at the moment now, you're talking about litigation. That, yes, someone has to go to court in order to prove one thing or the other, or disprove one or the other. So now it's about litigation. Someone is objecting, about something.